I believe that what you see in front of you today is the end result of some very thoughtful negotiations. And so, hopefully that we'll move forward with this and get this behind us. Our legacy here is that we are able to provide water collection services to the Ross Valley Sanitary District. We do it safely so that we don't endanger our constituents. We do it reliably so that the collection system works every time you need it from wherever you are in the system. And we try to do it as efficiently as possible without wasting the taxpayers' money, which, as we know over the past year, that I've sat in on, you are all very concerned about. Continue to try to get our costs down. That's what we do. As much as I've tried to discover somewhere where it says we're a land use agency, I cannot find that. Thank you.
Frank, do you want to say anything? Oh, I would have hoped there would be a staff report this evening. We received it Friday by email. We serve 50,000 people here in the Ross Valley, and I'm wondering how many of the 50,000 people have gone to our website and looked at the settlement. Is this an informed decision that folks are making this evening? So, do you know how many hits we've had on it in 5 days, Greg, on our website?
I don't, Greg.
You think 5, 10, 20? Maybe we went to look at the settlement?
I don't know.
So there's really no staff report, right, other than what's in writing? Is that what I'm being told? So the public is here tonight, they're not going to hear a staff report, they're just going to be able to comment on something, and then it's going back to the board. I mean, that's generally not the way we do things. Generally, we have a staff report. But at some point, I've got to ask some questions of some of the participants. So I guess you want to hear from the public. Let's hear from the public. But
We'll go into the public bit because I have a question.
Sure.
By requirement, I just want so that everybody can understand that we're here tonight discussing this in open because as a board we decided to do that. This is generally not the way that litigation is settled.
Correct. But it is settled that way. I did a search today. There are some public agencies that do open it up.
There may be some, I've never seen it.
Yeah, you have to dig, but
okay, we ready to go to public comment? We would ask that you come to the podium, make your comment. We're going to limit it to about 3 minutes. Please give your name and where you live. We're going to go to the public. We can't comment, and then we're going to bring it back to the board, and then the board is going to discuss whatever we decide.
Yes, my name is Mimi Willard. I'm from Kentfield. I have 2 points to make. The first one is has to do with the issues of land use. There have been allegations and protestations about RVSD's potential role in clearing the way for development at San Quentin or elsewhere. As I think you know, I have really not gotten involved in that issue. My focus really is on good governance. Well, now as part of that focus on good governance, I've discovered that real estate interests seem to think Ross Valley Sanitary District does indeed have a role to play here in the advancement of their interests. Specifically, in the last 2 elections of the district board, the only meaningful outside interest group to donate to the RVSD elections were those associated with real estate, builders, developers, and building trades. Now, honestly, I'm not pointing fingers at anyone on this board. I don't think your votes are for sale. I don't think that's motivating your decision. But my point is that while Ross Valley Sanitary might think it has no rule in land use within Marin County, the contribution pattern suggests that these donors think otherwise. If not, why would they not skip donating to this particular set of races and double down on other entities such as the Board of Supervisors races, where they are heavyweight contributors? My second point, this feeds into my second point, which is that there's a lot of community anxiety and suspicion about this particular settlement. The release of the settlement agreement and the agenda related to it for tonight's potential vote to approve the settlement was really, sadly, an unforced error. It's not an accident of the calendar, as there was no reason for it to happen over a holiday period. There's no good reason to rush, as far as everybody here tells me. Maybe there's something we don't know. So taking the time to have a public hearing process, be it 30 days, 45 days, whatever the number is, will reestablish a credibility which has been sadly dented by unforced errors, bad process. Council has told us at the last meeting that it's fine to have such a delay in order to invite more public participation. So I would urge you to please do the right thing.
Thank you. Next.
Yes, I'm Carol Page, San Anselmo. It's going to take me more than 3 minutes. This settlement settles nothing except to confirm 3 rogue directors' intent to betray the public trust. What you 3 sold to voters is a far cry from what you have delivered. Directors who neither recused themselves nor disclosed pertinent information per sections 1090 to 1099 violated the government code. In violation of Article 1, Section 3 of the California Constitution, there has been excessive, abusive use of secret, undisclosed meetings by the directors and interested adversarial parties to craft decisions and disenfranchise the public. Directors who protested the administrative silencing and have attempted to enable public participation are vilified. Most interesting, the impetus toward this settlement happened after the Sonoma Court's ruling favoring the district. The board terminated the law firm handling the litigation. Despite the newly chosen firm properly disclosing their client list includes San Quentin, CMSA, and San Rafael, preventing them from representing us against those agencies, you hired Downey Brand anyway. Was this adverse effect on the district's litigation representation by accident or by intent? Abandoning millions of dollars of infrastructure assets and relinquishing our largest income source slows capital improvements and raises liability. One sewer overflow cost us over $1,539,000 and added the performance demands of a cease and desist order. This settlement increases the likelihood of another crime and punishment epic. With this settlement, you abdicate to a JPA where Ross Valley ratepayers are wrongfully underrepresented, where we have no ability for protest or outside review of exorbitant and rising fees. This is fiscally irresponsible and another violation of Article 1, Section 3 of the California Constitution. The bond refi savings you advertise to us may be passed through CMSA's biased JPA to San Quentin, while Ross Valley customers pay higher rates for service and bond debt. Claiming this settlement will save money is demonstrably false. For 2014 forward, legal costs are over $320,000, of which San Quentin litigation is less than a third. That figure would be 0 if you had not squandered time on this worthless document. At your May 20th meeting, you approved close to $1.5 million on consultants, bonuses, change orders, and overruns. The comparatively small amount for litigation to defend our assets and income is a much better investment.
Begin to wrap it up, Carol. It's over 3 minutes.
I'm getting there, Tom. You who endorsed this settlement have chosen to serve other masters. I suggest you be honest, leave the district board, and go work openly for those outside interests. I am no expert on sewerage, but I do care about the future of this agency. It is time to make you heedless directors accountable for disregarding the law. You have received the 30-day notice from my attorney, informing you that we are going to federal court to find the district in contempt of an outstanding U.S. federal court order that you have chosen to ignore with this proposed settlement. Your actions demonstrate a pattern of continuing malfeasance and a disregard for your fiduciary duties and responsibilities to this district and its ratepayers under the
A few
Clean
more
Water
seconds now,
Act.
Carol. This
I'm
is-
done.
Okay, thank you. Next.
Hello, I'm Peter Hensel from Port Madera. This seems like another episode of Alice in Sanitation Land. And I'll tell you why. Everyone knows about Ross Valley Sanitary District's history of sewage spills and alleged corruption. But what's changed at Ross Valley Sanitary is the mindset of the newly elected board majority, who seem determined to end quickly, perhaps hastily, a lawsuit filed in 2012 that charges Central Marin Sanitation, a wastewater treatment facility, with poaching a long-standing wastewater collection contract with San Quentin. Under an agreement with the state, honored from 1981 to 2012, Ross Valley had been the wastewater collector as well as the provider of the infrastructure pipes at San Quentin. That contract, valued at about $1.2 million when Central Marin Sanitation took over, represented Ross Valley's single largest source of annual revenue. Paradoxically, new board member Michael Borski recently wrote in Marin Voice, Ross Valley is not giving away a valuable asset. The prison pipeline does not serve Ross Valley customers. 100% of the local cost was paid by the prison. This bold and potentially game-changing assertion is offered without supporting evidence. Surely it's an odd pronouncement from a board member, particularly when a Sonoma judge, in denying defendant Central Marin Sanitation's motion for summary judgment, wrote that material facts remain in dispute. A settlement agreement negotiated subsequent to the judge's ruling was kept secret until May 22nd and has finally just been released. In a rational world, a sanitary agency board works hard to both cut costs and preserve income as well as material assets. For transparency's sake, what's needed is 45 days for public review of the document in question before the Ross Valley Board votes to approve, possibly as early as tonight, in yet another closed session. Alice may be watching. The dysfunctional wonderland of the present Ross Valley Sanitary District Board just got curiouser.
Next speaker.
Valerie Hood, Fairfax. I'd like to read something into the record from San Quentin Village Association. I am writing on behalf of the Board of Directors of the San Quentin Village Association. It recently came to our attention that the Board of Directors of the Ross Valley Sanitary District and the Central Marin Sanitation District are meeting on March 9th and March 10th, 2015 in closed sessions to discuss and possibly vote on the settlement of the lawsuit by RVSD against the CMSD in connection with sewer service to San Quentin Prison and San Quentin Village, and to potentially work on agreements for service to be provided by CMSD to SQP and SQB. We are very concerned that the residents of San Quentin Village, who will be directly affected by any settlement and possible agreements, have not been notified of these meetings, that the closed sessions lack transparency and do not provide the public with the opportunity to review and comment on the negotiations. We are also very concerned that any contract with SQP, which apparently will include sewer service to San Quentin Village, does not allow any input from the residents of San Quentin Village who will be paying for the sewer service. We are also very concerned that the board of CMSD is not a democratically elected board like the sanitation districts in the rest of Marin County. All of the residents of Marin County can elect the board of their respective sanitary districts. However, if there is a contract between CMSD and SQP, the residents of San Quentin Village will not be allowed to elect the board members who would make decisions about sewer sanitation service to our homes and the rates we will be charged for such services. We ask that before any vote is made on these issues, that the board members of both the RVSD and CMSD hold meetings before the general public, and that the residents of San Quentin Village be notified of such meetings and be contacted by the agencies so that San Quentin Village residents can have a say in any dealings that will affect our sewer service. This is from Michelle Barney, Chair of the San Quentin Village Association.
Thank you.
Thank you for letting the public have a chance to speak before you make a decision. And I have reiterated numerous times that we should really have had all the discussions of this in public. And I ask for the transparency of numerous meetings because this is public agencies doing public business with public assets. And the public needs to have a voice, and the public has shown up and shown its interest in having a voice and in learning more about the intricacies of this situation. A few things I want to say before I read a letter from the Sierra Club Marin Group is that what Michael says about having a public trial would cost a lot of money and take a lot of time. I think that would be very good to clean up this board. This agency has had problems for years and years and years. It's really time that we took the dirty linen out of the closet, washed it, and let everybody see what's going on. I think that it really needs to go to binding arbitration. That's the most efficient, quickest way to do it. You shelve the settlement agreement, and let's get on with the matter, and let's get the public in here. It's interesting that I talked to someone today, mentioned this to them, and they said they come from the foothills, that this is going on in a foothills sewage agency up in the Sierra foothills. Now, this sounds like a playbook that is going on around the state for agencies to grab other agencies' assets and put them under their control. This is just fraud and theft of the public properties, and this is not a good thing, and you people should not be allowed to do this. And also, finally, I am really, truly outraged at this giveaway. It appears from what I have seen of what the settlement agreement is, that you are in fact saying that, gee, isn't it sad that even though San Rafael went and did a contract behind our back, and we called them on it, that we now say, oh, gee, we're sorry we caused a problem, and you can have all our toys, and we're very sorry we're going to go hide in the closet. Okay, this is what you're going to do. You're giving away all our assets, you're giving away all our revenue, and the Ross Valley people are going to have to pay for it. I think that is totally outrageous, and definitely this settlement agreement, if you decide that it's 3-2, go ahead with it, needs to be having a public airing for at least 45 days. And I'll read you this letter from the Sierra Club Marin Group.
Okay,
It's
you've
come
only
to our
got 10
attention
seconds, so
through
you're not gonna be
various
able to
news.
finish
There's
the
no
letter.
other way to get it into the record.
Well, somebody can
Because
read
the
it. No,
people-
we're not going to allow, you can't go.
I can call somebody else to read it
That would
into
be
the
fine.
record.
That would be fine.
I have a copy of it.
All right, I'll read it.
Into the record.
Okay, she's going to read it into the record. Thank you.
Thank you.
Grab my Bible.
Thank you.
Hello, Doreen Gleason, Kentville. And this is to the Ross Valley Sanitary District via email from the Sierra Club. It has come to our attention through various news stories and social media sites that there is a pending lawsuit settlement over what sewer agency will serve the San Quentin Peninsula, the state prison, and the San Quentin Village with wastewater collection services. While finding a fair solution outside of trial should be the goal, we ask you to delay any action at this time. A recent presentation to a community group as to the future of the San Quentin Peninsula by a high elected Marin County official brings the issue to the forefront, and we are concerned about any implications that a settlement of the lawsuit may be tied to the potential development of the San Quentin Peninsula. The potential ending of the death penalty, which could close death row, and the possible desire of the state of California to close and sell off their most expensive prison in the system to run, adds to our concerns. The Association of Bay Area Governments, ABAG, as well as some of the members of the Marin County Board of Supervisors, appear to support the San Quentin Vision Plan for a central transportation hub, ferry, and train, with 2,000 to 3,000 new living units on the point. Recently, when asked about the county's priority development area for the San Quentin Peninsula, PDA advocate Supervisor Steve Kinsey, who is the Marin County Board of Supervisors president, placed the PDA on the consent calendar a few years ago and said, quote unquote, not at this time. Given the fact that the local agency Formation Commission has embarked on a consolidation study of Marin sanitary districts, we, the Sierra Club Marin Group Executive Committee, respectfully ask you to delay any further deliberations on a settlement pending the sanitary district study outcome.
Anybody else?
Good evening. My name is Joyce Britt. I live in Mill Valley. The last time I was here, it was to ask you for, with a lot of other people, to open to the public your deliberations with respect to the settlement. That was an issue of process and an issue of the California Constitution that gives the public the right to public hearing. Tonight, I'm going to talk about substantive issues that really come from the fact that I read the Marin Voice article written by Mr. Borstein. Those substantive legal issues are the following. They really are grounded in the lack of fiduciary responsibility. First, the interference with a co-partner's contract, the enrichment of CMSA at the expense of the Ross Valley Sanitary District with respect to the capital expenditures that were invested by the ratepayers, the history of contractual obligations between San Quentin and the Ross Valley District, the failure of the Joint Powers Association principles and possible ultra-various acts in setting up a joint powers agreement with a tilted board to enrich CMSA at the expense of the Ross Valley Sanitary District. I think it is extremely interesting that the settlement that you are proposing comes at the expense of a district which is a co-partner with another district that seeks to disobligate the contractual relationship. So I'm really wondering that in addition to other constitutional violations, that you also have the one with interference of the contract as a public agency. Thank you.
Can you say anything? Anyone else?
My name is Clayton Smith. I'm from Mill Valley also. And I'm really struck when I listen to all these arguments. I keep hearing this quote that was in a book by Anais Nin, one of her famous quotes, lies create solitude. And when I witness all the closed-door deliberations that are going on and all the move to secrecy that seems to be predominant in this particular board. One is wondering, what's to hide? And why to hide it? And of course, the tell has been revealed here. It's that deep water dock over there on the 40 acres that seem to have attracted the attention of Mr. Huffman, which he was discussing with such enthusiasm and clarity at his small town hall at the Book Passage. His eagerness to convert that property into a transportation hub, he being a person who I think is highly affected with all this transit fetish that is the preoccupation of ABAG. And that you, whether we will ever know it because we cannot read what is the heart of a person, their actual intention, are somehow or another feeling compelled to be enablers of this future vast development project, one that is going to negatively impact the lives, not just of people living in Ross Valley, but everyone who lives in this county, including people such as myself who live on the other side of the hill. And you know this. You are not so benighted as to not understand the consequences of your actions. And so you must be held responsible for all the future negative outcomes should this hyper-development occur. It is yours. It is yours. And I feel very sorry for the county. We have elected such people as you over the years, and it turned this once beautiful county, a place with transparency, into what could best be referred to as an insider's paradise. Thank you.
Kathleen Mulcahy, Larkspur. Right after the holiday weekend, I was not even imagining that we would be here. I've spent a little bit of time tracking between this organization and Jason Dow's organization over here in the audience. In just a month and a half's time, it just baffled me at how things unfolded, as though there was a puppet string going through the doors of Agency A to District B to all of the rumors that hit the floor. So I attended the meeting here in April, and I brought some recollection to looking at what was proposed in closed session. And then I went over to the CMSA's nice headquarters and took a look at what was going on over there on May 12th, I believe. And all of a sudden that board, minus the two people from Ross Valley Sanitary District that stepped out, were in full awareness of what I believe is in front of you tonight, and that we got to see over the holiday weekend. And then I wrote a letter because I looked at the string of things going, well, surely how can this be that we arrive here in closed session on the 22nd, and I arrive over to CMSA on May 12th, and I find them agreeing on something that our two board members that sit here on either end of the three of you, majority in the middle, don't know anything about. And then I proposed this to Mr. Norby and yourselves in regards to your Brown Act violations. I did this on May 19th in regards to putting yourselves in this litigation under something that doesn't even exist in the Brown Act. It's a code that doesn't exist. The highest level of umbrella that does exist is under the area of local agency executive salaries, salary schedules, compensation. And from that particular April 22nd, of which some of us were here, President Gaffney reported out that there was no action taken, just direction given. So I went out to the Oxford Dictionary, and to me, I thought, well, goodness, if direction is given, that seems like an action to me. So in the Brown Act, when an action is given, what you must do is you must do a roll call vote. So that wasn't something that transpired. So I pointed that out in my May 19th letter to Mr. Murphy and the board. So all in all, I feel we shouldn't even be here tonight because that whole session on April 22nd was void. You put it out as a closed session in a non-existing Brown Act number, not even on the books.
You need to wrap it up.
And
You're out of time.
I know, Joe, I'm always like trying. So the last bit is that I just wanted to confirm that I never, though I got a letter from you in the response, Mr. Norby, I've never got the results of this transaction. Thank you.
Thank you.
Mr. Chairman, members of the board, my name is Kevin Haroff. I'm a resident of Green Bay in Lawrenceburg. I'm also a member of the Lawrenceburg City Council, although I'm not appearing tonight in that capacity. I'm only, appearing in my capacity as a private citizen. It also would be inappropriate, I think, for me to appear tonight on behalf of the City of Lawrenceburg because I've been informed by our city manager that the ratepayers within Lawrenceburg don't really have an economic stake one way or the other in the outcome of this settlement. So I'm not really here to comment on the merits of the settlement. I'm much more concerned about the process. I did have an opportunity to watch a video of the last board meeting where the settlement was discussed, and I was struck by the level of rancor and controversy among the different board members, the name calling and grandstanding, which I think is really inappropriate for a public agency. So as a member of the Sanitary District, or as an entity that's being served by the Sanitary District, I would encourage you to reach an outcome here that reflects comedy and a sensibility that is more appropriate to this public body. I do think that the settlement is a matter of public concern. And I think the public does deserve a more thorough discussion of the contents of the settlement, of the benefits that the settlement will realize for the public, and what the implications of the settlement may be for some of the larger issues that have been raised by some members of the public here today, as well as by the Sierra Club in their correspondence that was delivered to you and read to you today, which I endorse. There's actually no legal reason, and I'm a lawyer so I know a little bit about these things, there's actually no legal reason why a kind of public discussion that I've encouraged and that others have encouraged could not occur. This is not settlement of litigation, for example, a labor dispute with a disgruntled employee where concerns about privacy are important and confidentiality is an appropriate way to address those kinds of litigation matters. This is not that at all. This is a contractual dispute. It's all about money and assets and resources. And I think it is only fair to the public to have a full discussion, as I said, of the merits, the implications of the settlement, so that the public can understand, appreciate, and if appropriate, endorse whatever outcome you all decide to reach tonight. So with that, I'm finished. Thank you very much. Now I'm going to go run off to my daughter's 7th grade band concert.
Michael McIntosh, thank you very much for allowing the public to make some input. I share the concern I've heard of both the speakers, and really what I think everybody here would like. I'm sure if you were sitting on this side of the table, you'd also like to have transparency. I think many people would support many decisions you'd make if you gave them an opportunity to really know what's going on. But I do think the settlement is very important, and I question if there's been a feasibility study to see really what the financial impact to the individual ratepayers would be as a result of the settlement terms that you're accepting. So right now, we hear a lot about affordable rent. And the reason rents are not very affordable, one of these reasons are just here for how we tax things. So right now in the Ross Valley, that taxable rate for your sewer fee is approximately $692 on a year. The same rate is affected on a 10-bedroom, 12-bathroom mansion or a little 7 by 10-foot apartment. So this settlement is going to make the greatest impact on those people who can least afford it. Those people who can't afford it basically are currently being asked to subsidize the people that can. And although I see this on both sides, I hate using that word fair, it's not very fair. And I'd really like the board to consider, if you were on the other side of that equation, how you would like to be treated with transparency. The speakers before me are all correct. If this agency or any other public agency makes any decision that's associated in any capacity with the expenditure of public funds, that decision must be disclosed to the public upon request. I've heard many people ask here different ways, but I don't think there is. Where I've been spending my time for the last month is trying to get same compliance of the Marine History Board and for the way that they're looting that museum and selling things out the back door. The question that I've asked the museum board, which I think everybody here should ask this board, why would they put up with such public ridicule? Why would they be slammed in the public and have their integrity compromised? The reason why is because they know that if they open up their books, they'd be chastised even worse. So they're taking the lesser of two evils. I would like this board to consider that and reach out to your public, the people that vote for you. Because I think you'd find a lot of support if they really knew what you're doing. And that's the only question I see. Thank you.
Michael, where are you from?
Soundcloud.
Anyone else? Okay, we're gonna, if we bring it back to the board, it's gonna stay with the board. So this is your last chance.
Just a point of order before we get there. We've got two attorneys here tonight. We have a general manager. We've spent an awful lot of money, actually two gentlemen, an awful lot of money on this whole litigation. And we haven't heard from them. At one point, will we hear from them? You know, so what's happened is, it's like the fix has been in on this, and it's quite disturbing to me. That letter that came from San Quentin Village Association, that was sent to us back in March. I never got it. Maybe the rest of the board got it, but the San Quentin Village Association is an integral part of this whole litigation. That's why the County of Marin was sued over the San Quentin Village Association and the collection of their wastewater. That community group wrote us a letter back in March, and it was never given to the board. I guess it's like, only give the board the information you want them to have. Don't give them any information that may change their minds about the direction we're going. And have you all seen the letter from the San Quentin Village Association? I mean, this isn't something that's made up.
Wait, our public is done, so we're at the board now. We're back to the board.
Well, no, we're not back to the board.
Yes, we are. Yes, we are.
We're back to the board.
So if you're not back to the board, may I ask a question? If you have that.
Wait a minute, no, you can't. We're back to the board now. It's too late.
Wait a minute.
You just said it was still open.
I think the public has a right to ask.
I thought
No,
you
they don't. We're going to have a board meeting according to our rules. You had your chance to do.
I thought
So Frank said that he thought that it was still open.
He thought it was still open.
Okay, well then Frank, don't talk then. We'll go back to the board. You're allowed 3 minutes. Please get up to the podium.
Well, I only have one question, and
Well,
Joan Bennett Kempfield, is there any other letter that you haven't seen? You've got the same question. Exactly.
Any other letter received that they haven't been given?
Okay.
Are there any other letters?
Probably.
We can't.
Do you want to get up at the podium and speak?
Can you answer John's question?
No.
No, we can't speak when we're at the public. We cannot speak. Frank jumped up. I wasn't sure.
May I then go to the podium? Joan Bennett Kempfield, Can you tell me, have you maintained an administrative record for this entire proceeding, the entire discussions regarding relative to the settlement agreements starting way back in January? What is the process by which you maintain and keep the administrative record? Because in there, you should have any records that have been received from the public, not just the letter that Frank held up tonight, or any other letters received. So if this is the first you've seen this, you've got to ask yourself, are there any other letters that have been received by this district that have not been distributed to the board? And before you answer that question, you should answer that question before you proceed with entering any settlement agreements. There may be other letters out there protesting what you're about to do, namely approving a settlement agreement. Thank you.
Thank you.
Carrie Stabner, and I just have another question, from Mill Valley.
Mill Valley.
And I hope it's not just a rhetorical question, but the issue of Brown Act violations have been brought up here. And I just wonder, has a determination been made whether or not there were Brown Act violations? And if so, what are the remedies for Brown Act violations? And I don't think you want to go through with an important decision like this with such a muddied and unsettled record and such, you're holding the public back who only seems to want to know further details about a very important decision. So I would urge transparency and an answer to the question of whether there were Brown Act violations now and what the remedies are if there were. Thank you.
Thank you. Okay, anybody else from the public?
I have a point of order. Can that question be answered by council?
It can, but when we bring it back to the board, we can ask council.
Okay,
And I'd like it answered too. Okay, I don't think there's any more public comments, so I'm going to bring it back to the board. Okay, board members? First of all, would you answer the question about the Brown Act question? It was a...
Do you want me to answer the question of whether the board's been advised on the issue or the actual substance of the answer to the question?
Well, kind of just the results, a real quick summary of what your opinion was. Is that okay?
If it's your decision as to whether you or I reveal what council has advised the board because of attorney-client privilege. So if you'd like me to, I'm happy to do that. Okay, so
yes,
with that.
We need to have a roll call vote on that?
No, no, it's fine. I have advised the board that I don't believe there were any Brown Act violations on April 22nd, and I am working on a responsive letter to the member of the public who raised the question.
Thank you.
Okay, board members. That she was not here that night.
Wait a minute. Excuse me. To the board now.
I want to add, you're saying that there are none pending?
No pending what?
Brown Act violations?
I said that it was my opinion that at the April 22nd meeting, there were not Brown Act violations.
Oh, just at that meeting?
The specific questions that were brought up by the meeting.
But that does not mean that there are other Brown Act violations that may comply from other things that have happened?
That's always a possibility, I guess.
All right, thank you.
If there was a Brown Act violation, would you advise us?
I would like to think I wouldn't let you violate the Brown Act.
Good answer.
Thank you. Good answer. Okay, board members?
I've got a few questions if I may.
Okay, but you can't ask the public.
Since we have council here. So I'd like to ask our council, neither one of them can ask. I'd like to ask how many of our board members have asked for the disc of the pleadings and discovery? How many have educated themselves on this entire case, which has been going on since 2012?
It's been a while for me, but I have looked at it, but not just the last 30 days.
Well, there's a disc out. I'm just asking how many board members have asked for that disc to educate themselves on the issues of this lawsuit?
Ed, are you asking me?
Yes, please.
I believe that at one point a disc was sent to you.
Okay.
I'm not aware of it being sent to anyone else, but I would have to go back and take a look because frankly I can't even tell you the date of when that happened.
Okay, thank you. So the question I have is, how did we get here? How did we get here this evening with 3 settlements prepared and ready to be voted upon? We have apparently spent $450,000 to date on all of this CMSA stuff. That included the JAMS mediation in San Francisco and the summary judgment lawsuit in Sonoma County with Judge Witt. So as far as the settlements, so I'm going to ask our counsel, were you directed to prepare these 3 settlements we have before us this evening?
Yes.
The answer is yes?
I was asked to prepare, let me take a step back. I was asked to negotiate and prepare settlement agreements with the other parties, their returns.
Okay, so the next question is by who?
This board.
Can you name the board members that directed you to prepare these 3 settlements?
The board.
You can't name the individuals?
I'm sorry.
Well, here's what I'm getting at. What I'm trying to say is...
Director, let me answer the question.
Please.
The board acts as the board, not you, not President Gaffney, but the board. The board directed that I go about this process.
Okay.
I was initially directed by the board, to file a lawsuit. I was then subsequently directed by the board to negotiate settlements.
I'm just asking who the 3 were that directed you. Since I wasn't one of them, now we're down to 4. Somehow we got to this position, and someone has directed somebody. You know, what's interesting is a new counsel's advisor have not been any Brown Act violations. But in fact, if we were taking action in closed session and directing you to prepare settlements, that was an action by this board that should have been reported out of the closed session. It wasn't reported out. So that's why I'm trying to just pin, I am trying to pin you down as to who the 3 were that directed you to prepare this settlement.
Well, I think you should also, again, I mean, does the board want me to discuss confidential communications in this public meeting?
May I make a statement?
Can I also add that I view it as a little inappropriate to be talking about what happened in closed session, given that it's unlawful to disclose what happened in closed session under the Brown Act. If you want him to answer and try to remember that that's one thing, I find it a little problematic.
Okay, let me finish my line of questioning then. In your briefs, and I've read them all, and you actually did a great job. In your briefs, you continually said force main number 11 that runs from inside San Quentin State Prison, from pump station 11 to the interceptor, the 54-inch interceptor, is owned by the Ross Valley Sanitary District. I've read all your briefs. It was from JAMS to the court in Sonoma County. That's been the position of the Ross Valley Sanitary District. We own pump station, we own force main 11. Now you seem to have changed your mind, and you say we no longer own force main 11. So I'm wondering what happened in between the time when you were arguing for us in court that force main 11 belonged to the taxpayers of Ross Valley, and now it no longer does. I'm trying to figure out how we got from here to there.
You're starting with a faulty assumption that...
Kristen, could you speak up, please? It's very difficult to hear you.
I'm directing my comments to
I
the board.
understand, but we're here to hear it too.
So, one, I think we're talking about the 16-inch force main, correct?
The 18-inch force main, yes.
I believe it's 16, but, okay, as long as we're talking about the same
Yes.
because we've always called it, I think it was 2A, but 11 kind of makes sense. But we are talking about the same thing. You're making an assumption, Director, that I control how Ross Valley positions itself regarding settlement, regarding litigation. And that's unfair. Because it's not, I have not decided, I've changed my mind about a certain strategy. I was given a task to do. That's what attorneys do. We don't, it isn't our personal opinion. It is not our desire to see a certain result. We represent the client. And in this matter, I was hired to litigate a lawsuit based on, among other things, ownership of the 16-inch force main. At a point in that litigation, there were settlement discussions that you are well aware of that, in fact, didn't involve me. And then at one point, I was directed to implement the settlement agreement. And that's what I've done. So
Is that what you have before us this
let me
evening?
finish. Please, let me finish. So I take exception that I have somehow done something that I'm not supposed to. I've done exactly what this board has directed me to do.
Okay, so.
Which is my client.
I understand. So we paid you $450,000 and you put the data together. I didn't know we owned that force main. I didn't know it until you gathered the information and data. We were led down the path by our attorneys, and all of a sudden they changed direction on us. You know, I always expect our attorneys to give us the straight information, the good, the bad, the ugly. So I believed everything you said when you said we own force main 11. And now we don't own force main 11. It's kind of shocking that we would have spent $450,000 of our ratepayers' money on a lawsuit that now you say wasn't true. I mean, it's really shocking. For instance, and then here's one more question. Maybe both attorneys and Andrea may have a better answer than this one. So is the transfer of the $2 million Ross Valley assets, this force main that runs from inside San Quentin Prison along Sir Francis Drake over to the 54th Interceptor, is the transfer of that $2 million asset a project under the California Environmental Quality Act?
Well, something is a project under the California Environmental Quality Act if there's a likelihood that it'll have a substantial impact on the environment. So that would be the question to be answered. And I'm not sure I have enough facts to know whether that's the case.
Let me just ask a question. When we come to an attorney as an entity, and we say we'd like you to represent us, we are assuming that we're not guilty. That's why we come to the attorney, because we feel we have a case. It doesn't mean that we're going to win that case. It doesn't even mean there's a likelihood. But it is your job, to the best of your ability, to look for legal reasons and represent us towards that end. And if there was confusion about ownership of that pipeline, but we felt that we had one way of looking at it, and the other people felt that they had a reason to look at it differently, that would be the reason we'd be doing a lawsuit. It doesn't mean they're right, it doesn't mean we're right. But you have to represent us to that end.
Yes, and I'm sorry, are you finished?
I think so.
Yes, I mean, the legal dispute about the ownership of the pipe, and the facts, again, the district board wants me to discuss this in open session.
Yes.
I'm a little reluctant, because if settlement goes forward, okay. If it doesn't, I've just revealed certain legal issues that I would prefer that CMSA not know. So the board needs to make a decision. Well, it has nothing, well, I'm also being filmed, so I'm reluctant to want to start divulging certain responses that could jeopardize this lawsuit.
That's the advice you've been giving us the entire time, right? That's
Yes.
why you folks have wanted it in open session. Our attorneys have steadfastly told us, nobody negotiates a settlement in open session. You don't do it. How can you negotiate in open session? So we're turning it over to, we're having an open session, which our attorney just told me nobody does, but we're doing it. So I don't mind if you give up attorney-client. How about the rest of you?
Well, as an attorney, I don't feel comfortable with it, but if it is to undermine Frank's assertion that our attorneys led us down a path, that they were in fact operating without the board's direction, then I guess it would make sense. Because that, to me, is something that it's a notion that we all need to understand is false. Our attorneys do not do anything that we as a board do not direct them to do.
No.
Christian does not make a decision about whether he thinks we own the pipe or whether he thinks we don't own the pipe. That is a legal question. He is willing to argue that we do when we direct him. He is willing to settle a case that says we have decided this battle is not worth fighting when we direct him to do that. That is what lawyers do.
Hopefully when he makes the pleadings,
Wait a
he
minute,
believes
you're
they're
not allowed
true,
to speak.
because
You're
you're
not gonna
under an
open this up.
obligation.
I'm sorry, stop it.
Under an obligation.
Back to the board. I'm telling you, if people keep blurting out, I'm going to stop the meeting and ask the person to leave. Do not keep blurting out. It's back to the board now. The ownership of that pipeline is under dispute, correct? They're asserting that they own it. So that's a dispute.
Absolutely.
Who paid the local cost? Who paid the local cost for that pipeline?
The prison believes it did.
Here's Exhibit A of the Joint Powers Agreement. It says allocation of local cost. San Quentin Forest Main, Ross Valley Sanitary District, 0. San Quentin Prison, 100%. San Quentin Prison Pump Station, Ross Valley percent, 0. San Quentin Prison, 100%. We did not pay for either the pump station or the pipeline.
Where'd that come from?
The JPA, it's Exhibit A right out of the JPA, page 3, table 3.
So we've been misrepresenting our ownership to the courts for 3 years and spent $450,000 misrepresenting our
Well, Frank,
ownership?
now I think you're getting it, because that's the way I felt all along.
I respectfully disagree. Well, it looks like someone needs a scapegoat, so. Look, we were directed to file a lawsuit. And the basis, the crux of this lawsuit has always been the easement. The easement.
The easement.
The easement.
Okay.
We own an easement.
We Ross Valley?
I'm going to leave it at, we own an easement, without going any further.
Where does the easement-
16-inch force main.
Where does it go?
That's where I'm not going to discuss, because I've already told the board these things, and it's, in my mind, that's a critical issue if you start getting into that. But the 16-inch force main was constructed. There was an easement granted for the, among other things, maintenance, repair, replacement, and building of the 16-inch force main. Why would Ross Valley own an easement if it didn't own that item? So, Director Egger, I don't really understand why you would think that I have misled this board, because that has been the crux of this case, and our position in this case, from day one. The board made a determination that regardless of the merits of that argument, it was not worth pursuing anymore.
What board?
This board.
What was the vote? What was the vote?
Again, Director Egger, I am not at liberty to discuss.
Well, somebody better
what the
start
vote.
telling the public who the 3 board members were that made the
If you would
decision.
like me to finish, so I've been accused of misleading. And so I think I should have at least a fair attempt to to rebut that.
I believed you the whole time.
So what changed was the direction I was given as counsel to the Ross Valley, not my position about ownership of the 16-inch force main.
I'm gonna make a comment.
You may.
I'm new as of last July to this board. Before last July, I was privy to everything that you all saw. No more, no less. I knew what you knew. And when I came into this thing, I had heard talk about we own certain things and this, that, and the other. And it seems to me that just because you bring a lawsuit, even if you have the idea that you can win it, doesn't necessarily make it right. It seemed to me that we're sister agencies in this thing, that there's this thing called CMSA, which we created, along with Santa Fe and Corte Madera and Larkspur at the time. And lots of things have happened since then. What I understood at that time was that some of the lawsuit had been filed during a time when the guy who basically brought it to the board at that time to do it was currently sitting in jail. So one has to say, well, I had to say, not one has to say, I take full responsibility. I said to myself, you know, maybe there's something a little weird here. I don't know if this is a good lawsuit or a bad lawsuit, but I thought, you know, let's look at it because maybe there's a different way other than just litigation, like I said before. So that's how this whole new thing restarted again. And keep on hearing talks about secret talks. The board at all times was kept informed, and the board gave direction. At the beginning, we actually all gave unanimous direction, as I recall it, because it is not in the record that we can record. We all thought it would be a good idea to, let's see if we can just not take this through the courts. There's an underlying focus here. There are people from Mill Valley. There are people from San Rafael. No, and you're here. Thank you all for being here. Thank you for being here and missing the Warriors game. But you're all concerned. And are you concerned about the poor ratepayers of the Ross Valley? Are you concerned about
democracy?
Okay. Are you concerned about our assets in the Ross? I mean, there are big concerns out there.
I'm concerned about democracy.
I'm concerned about you. I've been asking
I'm sorry, what are we doing here?
That's right. What are you doing?
Listen, I hear all this talk about transparency and democracy. This board asked the California state to come and audit us. They didn't just come by and do a little audit. They spent a huge amount of money. You've all seen it. You want transparency? We gave you the full results of that audit to the public to scrutinize, to look at. Anyway, let me get back to it. I digress just a little bit, and I don't want to take all night here. Just because you have some legal precedent, in my mind, does not necessarily mean you have to go get it, just because. I mean, I've been yelled at since last September about summary judgment. Summary judgment doesn't mean you won. What I've understood means I'm not throwing it out. That there are facts that exist, that if you felt like litigating it, go ahead and see what happens. Doesn't mean you won. It doesn't even mean you have the upper hand. Facts exist that we're not throwing it out summarily. And that's where we stand. I don't see the underlying thing that I see. I got a thing today from an email from somebody who said, you know, the people of Marin are watching you. They're not watching us because they care about, they care deeply about the idea that San Quentin may someday turn into a development out there. That's the underlying focus here. And I keep on coming back to me that I don't see this agency as being a land use agency. That's what I keep on asking. Are we a land use agency? We had LAFCO weigh in on this. No, they said we're not. I don't want to beat the dead horse here. I came into this thing, I think the lawsuit was given to us with good intent by the board members from a bad general manager, from years of bad running of this by previous general managers, and that lots of bad stuff was happening. A lawsuit will not solve that, make it right, or anything else. I do not believe that anything we decide tonight will have any impact on future development of San Quentin. It can't.
Have an impact on rates.
Well, let me ask a question because, Greg, I think we discussed this yesterday. What if we just end the lawsuit with the negotiated settlement? Well, let me just, one more thing. Our main argument during this whole time has been that CMSA contracted illegally with San Quentin State Prison. That was the main argument. This board unanimously voted, after much deliberations and thinking about it for a whole long time, to sign the bond refinancing documents of the Central Marin Sanitary Agency. It's going to, that immediately saved us millions and millions of dollars over the next 17 years. 6.5 million to be exact, I think. Very, very close to that. When we did that, we were advised by our lead litigator here in open session during that meeting over at the headquarters, that that was our main argument. And by signing those documents, no matter what we put into that agreement, we were effectively giving up our central argument, the entire lawsuit.
What? Could you repeat?
Okay.
No, I just.
I will. The argument was that Central Marin Sanitation Agency contracted illegally with San Quentin State Prison. Also, let me just state that I've heard a lot about how Central Marin went and poached one of our clients. San Quentin State Prison had questions about their bills from us, which seemed to have been hyperinflated. And from a general manager who's currently in prison.
We're off track.
No, we're not. I am talking.
This is on track. We're talking about a settlement.
I'm trying to address how I came to this decision as a board member.
No, you're trying to fit it on.
You guys, hold on. The board has done exactly what we've asked. I'm not trying to pick side.
Okay, no, please.
We don't want
Thank
to
you.
comment.
Look,
No, I'd like to
okay,
understand
very quickly.
What changed the equation?
For me, the equation was we shouldn't have ever been in this lawsuit to begin with. They didn't steal, these people did not steal anything from us. We're a nonprofit organization. We don't make money. We can't charge San Quentin and make more than it's costing us if you include a little admin cost and a little capital improvement cost. That's what we can charge San Quentin.
But they're under.
And we were hyperinflating our bills to them. As this is my understanding, okay? They went to look to see if they weren't able, my understanding, and I wasn't there, and Mr. Richards is currently in jail, but apparently they asked him for information about how they were getting their billing. And he was not giving it, and he didn't tell the board a lot of things, as I understand it now. He's not a good guy. They went around us to try and find a deal that would make sense for them. They were trying, as taxpayers, to save the state of California some money. Anyway.
I don't think you're allowed to do that.
That's the basis of this whole thing. I don't believe, again, bottom of my heart, we are not a land use organization. San Quentin's not shutting down anytime. That's my belief. I could be completely wrong. I can't find a thing that says it is. And we should stop this. There are so many things that we can do with our sister agency here to save us all some money, to save the ratepayers of Ross Valley Sanitary District money that we can't do with them now because we're in the middle of a lawsuit. We can't do anything with Santa Fe because they don't trust us either. Because believe it or not, they're in the middle of this whole thing too because they're paying Central Marin Sanitary Agency's bills. Corte Madera also. All these people are dragging, and what do, and at the end of the day, what are we going to get if we litigate? We can't litigate, we gave away our argument. That's my mistake. Okay, I'm done. It's just.
Michael, thank you. May I ask a question on that?
No, ask me later. You can email me and I promise you I'll respond.
Any other board comments?
Sure, of course. I mean, we haven't even talked about the settlement yet. We're just talking some general discussion. So it's interesting, as far as the ownership of the force main that runs from inside San Quentin State Prison, and it's over towards the H unit, out to Sir Francis Drake, along Sir Francis Drake, down to the little subdivision, that's the last subdivision in Marchburg, and it goes through on the 54-inch interceptor. So the state of California, Department of Corrections Rehabilitation, deeded to Ross Valley Sanitary District an easement so that their pipe, Ross Valley pipe, could run onto state property and connect up to pump station number 11. In our last report, at the last meeting, we had a report on the work we're doing. We just issued, millions of dollars in contracts. And it shows, that page showed pump stations and force mains. It showed pump station 11 over here on the Ross Valley side. Forever, Ross Valley has maintained that pump station until it lost the contract in 2012. The only reason we had the right to be in here is because we own the pipe going to the pump station, and they allow our employees to come onto state grounds to do the work that was needed to be done. It was mentioned earlier about how this settlement came about. So since we're talking a lot about some things that happened in closed session, I remember the night President Gaffney came before the board in a closed session. I call it a secret meeting. It wasn't announced that he was making a proposal that Supervisor Rice mediate this lawsuit. That night in closed session, I said, I see a problem with that. Supervisor Rice, in effect, is a defendant in the lawsuit, number one. And number two, she's also a director for the San Rafael Sanitation District. I said, I don't think this is good. That's way back, probably October or November. I mean, we're talking way back. So we've got these settlements. I don't know if we're going to take them one at a time or what. Are we going to go over them one at a time? Or is it going to be one motion that approves every settlement here? I'm not sure what the process is yet. But at some point, we have to talk about them. I would imagine they have to be approved individually. And if they have to be approved individually, then we're going to have to talk about them, and the public's going to have a right to comment on the specific settlement that we're talking about.
Not so, Frank.
So if I may finish, I'm not quite done, okay? It's interesting, it said, water is no longer a reason to deny development. The state has passed certain laws, and water is no longer a reason to deny any development application, water supply. But what's interesting, what is still accepted by the state as a reason to either reduce, reject, or modify a development proposal is sewer service. Specifically in the state codes, sewer service is a reason to either approve, deny, or modify, amend, and development application. Ross Valley Sanitary District is under a state cease and desist order. We've had some spills. We've done a great job in correcting it, but we're still under the cease and desist order. Central Burn Sanitation Agency, to my knowledge, is not under a cease and desist order. So if an application came in down road for 2,000 to 3,000 units over at San Quentin Peninsula, I'm not sure that the Ross Valley is in a position to say, yes, we're ready to handle, we can handle all of the sewage that's going to be generated from that development or developments. We're giving away $2 million worth of public assets. Our council's done a good job in documenting who owns what. And we do own the force main. You look at everything. I mean, I spent days going through the record. I spent days reading the CD that was delivered to me. I spent days reading consolidation studies for 3 times. And I think President Gaffney did one of the consolidation studies. I mean, I read them all. I did the research. And you know, I'm really concerned that one vote tonight is going to decide this whole thing. One vote. So what recourse does a taxpayer have? I'm not sure. They're going to be facing a large tax increase. But we talked about, we're going to benefit from the sale of bonds. We're going to benefit from the sale of the bonds from CMSA, and we are. But also at the last CMSA meeting, we wrote a letter to all of the JPA members saying, by the way, in 5 years, there's going to be a fairly large increase in your CMSA costs. We're looking at probably $1.5 million a year increase in our costs. So we're going to save $600,000 or $400,000 a year over here, and over here we're going to be charged an extra $1.5 million, perhaps. Now, in these agreements, generally when there's a settlement agreement, and I've been involved in an awful lot of them, there's consideration for both parties. Somebody gets something. Each party gets something out of the deal. In these 3 settlement agreements, Ross Valley gets nothing, 0, nada, nothing. There's no consideration for the Ross Valley Sanitary District and the ratepayers of the Ross Valley. So, you know, just a little insight about how public agencies function. Sometimes they do well, sometimes they don't do so well. When you take a highly contentious issue and you decide it on a 3-2 vote, there's going to be repercussions, no matter what we think, if we're doing the right thing or the wrong thing. To take a highly contentious issue and decide it on a 3-2 vote and think that everything is just going to be just fine tomorrow, it's not going to happen. It's going to impact the people who live in Ross Valley. You know? Nobody's running down here saying, sign a settlement. In fact, everybody's coming down saying, gee, please don't sign a settlement. Why don't you give us some time? Let's take a look at it. At what point will we discuss each settlement agreement? That's what I'm wondering. Right now?
Hang on, can I just?
I'd like to let Frank finish, and then I'd like
You
to
just
speak.
said I could go.
Michael, you've spent about 20 minutes.
At least.
At least, and I haven't really done
You'll
anything.
be
So
next.
I'm asking the president to be fair and not partial. Thank you.
Okay, I
You'll
yield.
be next, you'll get your turn.
Less than a minute. I believe it was back in August or September, one of the first times here, when we talked about possibly reopening the thoughts about a negotiated settlement as opposed to litigation. Those were really our 3 choices. Drop the lawsuit, which I never thought was a good possibility. At that time, we thought we could send a team to work with Central Marin Sanitary Agency. Director Edgar and Director Miggs couldn't be on that team because they were already members of the Central Marin Sanitary Agency Board, okay? Mary didn't want to go because she's got 2 young children and wanted to spend a lot more time after having spent the last year as the president. That left Tom and myself. My nose was still wet.
That's a minute.
I asked for the meetings. It was me, not Director Egger, not Director Gaffney. It was me. Thank you. Go ahead, Pam.
No, Frank, you done?
Well,
We can come back. We can come back.
we have to talk about the process here. We have 3 specific settlement agreements, and generally, when I've dealt with a settlement agreement from either the local, state, or federal agency that I belong on as either a commissioner, council, mayor, or board member, we've taken the settlement agreements one at a time. I've never sat down and signed 3 settlement agreements in one motion. I think we've got to look at each settlement agreement. I don't understand the process here tonight. We've got how many years? We've got 3 years of litigation, discussions, and it's gonna come down to one motion, by the way, one motion, approve and go forward. I've got folks here don't even have no idea what's in the settlement agreements. At some point, we have to tell them what's in the settlement agreements.
Okay, all right, so somebody said tonight that they were very concerned about the process. Who was that? Are they still here?
Everybody.
Well, besides everybody, but someone actually got up and said that.
Kevin Harrell.
And that has been the biggest part of this, besides the democratic process. But process, open process, is really the democratic way. And I have to say it has, for various reasons, and I'll go over some of them, there's too many unanswered questions. There is too much of a lack of this agency. And by the way, thank you for being here, coming out on a night, and I'm sure you'd rather be home relaxing. So I just wanted to say thank you, first of all, for being here. So the meetings that happened, I have, by the way, and I am part of the 2. And the meetings were shaky, it was kind of like, well, this happened, and no minutes were done, there was no attorney present. And then I found out kind of pieces that came on later that now Katie Rice was involved and other people were involved, and I thought, what the hell is going on? And so my trust issues my antennas went kind of started by then. So, and that's why I still do not feel comfortable with the settlement, and the public process was just not, didn't happen. There's other questions about, we really don't know what a cost of a trial would be. We don't really know. I got an email about what would it actually cost the ratepayers. Though Greg is saying nothing, but I want to see that done in a professional way. I don't like one person saying, oh no, there's no cost. I want to see it measurable. I want a consult done, whatever needs to be done. I don't want someone saying willy-nilly, well, yes or no. So, there's been some problems about potential Brown Act violation. I actually went to a Katie Rice fundraiser, and she announced last week congratulating the RVSD for their litigation was now over. It was now over. And if somebody can't remember when we're having our meetings, it sounds like this decision was done a long time ago. And I hate to say it, but that is not the way you do a settlement. You have the public process, you allow them to speak. This is your money, this is your agency, and we are all voted here by all of you. So I also want to say, trust is one of our biggest problems here, and transparency. It's been this way for what, 2005 and prior. And I kind of hear what the other board members are saying, some are very focused on money. It's all about the money. The attorney fees, I don't really care what we settle, just settle it, it's about the money. And, or it's the projects we need to do. But, you know, it is more than that. It is more than money. And I don't really think you can put a price on democracy. I just don't think you can. So, kind of looking at this more and more, I feel very uncomfortable with voting it, supporting it. I think there's been a lot of backroom deals going on. Of course, I don't really know, but it's some of this kind of bits of information. Hearing a couple of board members even talk behind here before a meeting one night, and they were discussing it openly. So it just gives me the flavor of not trusting the situation at all. So I'm not surprised that the public doesn't trust us. You know, it's like you smell something fishy. You just smell something fishy, but you don't know quite where it's coming from. So how do we move ahead? You know, we looked at the process from the past. We're looking now at the current process. We have a settlement in front of you. It was me that asked the board to bring it to the public after the attorneys told us vehemently for weeks that we could not do that. And then we have a guest attorney, because our attorney's out, and he said the board can do whatever they want. You want to vote it to be public, you can. And these are the mixed messages we've been getting from the attorneys. It happened with the refi. We were told, oh, if you vote for the refi, that means the lawsuit's over. Then we find out later, oh no, it doesn't matter. You can do whatever you want. So it's this ongoing public trust issue, and I do my best. I really do. It's just it's like this weird thing that just keeps coming forward, and that's one of the other reasons that there's too many things that are odd, precarious, too many unanswered questions. There's no way in hell I'm going to support a settlement like this. So how do we move ahead? Do we ignore the public and just vote the majority here? Or do we let the public come back within 2 or 3 weeks, give us more feedback? The one thing that I did not see, and that was a citizen advisory group. I really believe if we had done that process through along, and maybe I just wasn't paying attention, or the attorney was saying, oh no, you can't talk about anything, we could at least gather information. While we may not have been able to give it out, gathering that kind of information would have been so vital to help the settlement look at it, you know, more fairly. And the lawsuit came out of trespassing. That word, I don't know if that it's been said tonight, but it came out of trespassing primarily from what Christian had told me a long time ago. And so I sort of look at, now if somebody trespassed at my house, how would I handle it? Are they breaking the law? That's that's why I went to the judge in Sonoma and said, yeah, CMSA did an appeal. The judge says, no way, this can go ahead to trial. So you kind of have to look at all the parts of the puzzle to kind of see how you can make a decision. And it's been a rough, year on this whole process. And I was a planning commissioner for 8 years, and these were extremely contentious meetings about land issues. Your land is like your blood. And a lot of fighting, and a little bit of flavor about some of this that's been going on. And what really got to me, what I noticed the most was that some people just want to make a decision. And they want to make it according to their values, what they think, and that the outreach of the total elected community is not acknowledged. And I'm telling you, it is about process. And I don't feel that the majority here, and maybe that's not a kind thing to say, I don't feel that it's been like pulling teeth to let the community be involved. So looking now for the future process, I'm kind of hoping that we can start afresh with this 45-day wait, if that could be hopefully granted by the board tonight. Maybe answer some more questions. Maybe look at the binding arbitration. If the JPA wants to deny it, so be it. Let them deny it. At least it's put on the table. It hasn't even been put on the table. All I hear is, oh, the JPA members will never agree to it. Well, I don't really know that until it's there. So, and maybe we need new people in there to negotiate leadership. I mean, totally new people. So that's kind of where I'm at right now. I know LAFCO is going to be in the process this year of looking at our agency. And I hope there could be a different settlement where both sides could win. Potentially maybe CMSA could create their contract to continue. We keep our pipe and pump and we drop our lawsuit. This way, to me, would be more fair, is to open it up and have new ideas come forward. So, if we also move ahead, what will the fallout be? I kind of guarantee it, there's going to be lawsuits. There may be recall. There could be, you think that just by the settlement, everything's just going to magically go away. I don't think so. Not when you have this many community members and this much public here telling this board that they want openness and transparency. They don't want 3 to 5 days during a Memorial Weekend holiday to review a settlement. So it's kind of sad in a way that I think the bellwether indicator here is the politicians. It's much more the politicians than the public. So hopefully we can regroup. I'm asking the board for that. And I think when we look at how we got here as elected officials, I think you need to pay attention. Why did you get here? Did you only come here to end lawsuits? I think there's much more to this agency than ending lawsuits. So it's really a tragedy of the commons if you move ahead tonight. I really believe that. It's a tragedy of the commons. I don't know if people know what that means. It's like there's a group of people that look at more of their own initiative and what's good for the rest of the community. So that's kind of where I'm at.
You finished?
Yes, Tom.
Okay, next.
For right now.
Frank, do you have anything else?
Well, I'm wondering about the process here. I mean, does council really believe one motion is going to approve three separate settlement agreements?
I don't believe that a separate motion is required for each.
Really? You don't think we have to settle out with each agency separately?
I think you can have one motion of the board procedurally that does three things. I mean, unless Christian feels differently, I don't see any procedural problem with that. It's the board's discretion as to whether you do three separate motions or one, and or whether you discuss each one separately and or how you discuss it or deliberate.
Well, at some point, I have to discuss the three settlement agreements. So whenever you want to do that, we haven't even talked about the settlement agreements yet, just right now. Going to talk about it now?
Yeah.
Settlement A. Settlement A is a settlement agreement and general release.
Between who?
Well, if you're asking who between two,
There's three.
have you even read these agreements?
Right, there's three. Which one are you referring to? Which one do you want to start with?
I think you're talking about attachment A.
No, I'm sorry, attachment A.
Okay.
I call it settlement A.
Well, whatever.
Or settlement.
I'm asking you between who?
It's A, so it's Ross Valley and CMS.
Don't do that.
So here we got, and if you look at the agreement, the scope of the agreement, no admission of liability, okay. Attorney fees and costs, each party's gonna bear their own. In the settlement itself.
Excuse me, could we read each settlement? allow public input, please? You've done a very good job about
No.
opening it up to the public.
It's in the back, and you can
No,
read
it's
it.
not. There were no papers back here.
It's not there.
There is no staff report, there is no public copy, there is nothing.
There's nothing for us to
There is
look
no
at.
agenda.
There's no agenda. What happened?
Here is what's back here, public copies.
Oh.
Right there, this is the public copies.
Does that say March on it?
March, come out of here,
There was a staff back there when I came in.
We put them out on the website, we have a long distribution.
There was a stack back there when I walked in.
You always have public copies.
There was a stack back there, right where Gerald is sitting when I
Well, I
walked
can
in.
assure you, there's none here, there was
I
none here when I
understand
came
that.
in.
There was a stack when I walked in the door tonight.
No, there wasn't. I didn't see it. The text dealer? Yeah.
Anybody take any else?
Okay, settlement A.
Okay, settlement A, we're looking at, I'm just going straight to four, the settlement, what it says. The first one, it says CMSA and Ross Valley Sanitary District agree that San Quentin Prison, through either the California Department of General Services and/or California Department of Corrections and Rehabilitation, may directly contract with CMSA for wastewater services. CMSA has always treated the wastewater from San Quentin State Prison. Always, for the 30-plus years that Ross Valley had that account, and currently, CMSA has always treated the wastewater. And that's because CMSA is a treatment agency. CMSA is not a collection agency. So right now, this is gonna require a change in the Joint Powers Authority agreement that's gonna make CMSA now a collection agency. We know they're a treatment agency. It says it's spelled out in the JPA, they're the treatment agency and we're the collection agency, but now they're gonna become a collection agency by result of this portion of the settlement. Then it says CMSA and Ross Valley Sanitary District agree that County of Marin may contract directly with CMSA for wastewater services for San Quentin Village Sewer Maintenance District. We've heard from the people who live in San Quentin Village, they're opposed to this settlement. They don't want this settlement. But I guess we really don't care what San Quentin Village thinks about it. The people are going to pay the bills. Next it says CMSA and Ross Valley agree that County of Marin may, no, I just covered that one, I'm sorry. CMSA agrees San Quentin State Prison shall be billed on its wastewater flow and strength in the same manner as JPA member agencies. So now San Quentin is going to be equal to a JPA member. At the CMSA meeting, I said, you know, if we want San Quentin to benefit from the refi, why don't we bring them in and make them a JPA member agency, and then they can get all the benefits of being a JPA member agency. Water flow and strength is how Ross Valley charged the California Department of Corrections and Rehabilitation all the years. You know, I had our staff just run some numbers for me, and it climbed dramatically in like 9 and 10, 10 and 11, and then it dropped back down 11, 12, because San Quentin put in effect water conservation. They reduced the strength of the sewage coming out of San Quentin, and so we lowered their bills tremendously. Cut it in half on the last year we had it. CMSA is prohibited from providing wastewater collection or treatment service to properties located within a JPA member agency service area unless explicitly requested and approved by that specific JPA agency's board. So this says that, right, CMSA just can't go in and be a wastewater collector for either Santa Fe or Corte Madera or Ross Valley without that agency's approval. Well, if this is adopted tonight, if it's approved, we've just given approval for CMSA to come in the Ross Valley Sanitary District area in the San Quentin Peninsula to collect wastewater.
Can we just, so you brought it up, can we discuss?
Sure, yeah, you can, yes.
So what changes? We listed all those settlement agreements. What changes? Nothing, except one thing. We get an agreement from CMSA that they can't poach. Nothing else changes. This is the status quo. This is what is happening now. CMSA is contracting with the prison. They're already doing it.
That was our largest customer. They poached it. It's gone. And we're agreeing to it.
San Quentin Prison shopped the fee. They went out and checked the fee. They're paying, instead of paying $1.2 million, they're getting probably a better service for about $100,000 plus.
What?
That's how much they're charging for the collection.
There's no bidding
And that's what
process.
that's all we were charging for, is the collection. In fact, all we were charging for is to operate the pump station. Anything else that we collected, we sent to Central Marin. So for our work to operate that pump station, and quite frankly, when Central Marin took it over, it was in deplorable shape. It was in deplorable shape. We were charging, in essence, $1.2 million just to operate a pump station, one pump station. And we never, I can assure you, I don't think human eyes have seen that pipeline. I doubt if anything has been done to that 16-inch pipeline.
We didn't maintain the force main?
We didn't do anything.
We own it, but we didn't do anything.
Well, it's in dispute who owns it.
That is it.
We didn't pay for it.
President Gaffney.
No, they got
No questions. No, come on, stop it.
They got state and federal clean water grants.
We all did.
That's
They
in
did.
a day when those grants used to be available for sanitary districts.
That's right.
To do work. That's where the money came from for all of us.
No, but there was a local cost share, and they paid 100% of the local cost share. So any other comments? I mean, we ought to discuss all these points, each time.
Okay, I'll bring up something on this overcharge fee, because I've been on the board, well, Frank and I've been on the board the longest. So the measuring ability was questioned on our side and their side. And Jason, you can tell me if I'm wrong. But it was never clear how that was measured for the charge. Then San Quentin put in a very strict conservation program, which would drop the strength factor, which would drop the cost. That also was never specifically measured in a way that either agency shared nor trusted. So there's that piece. The other piece is CMSA, when they did the contract with San Quentin, we were never approached to say, like a bidding process. Public agencies, there's a fair bidding process. That never happened either. That's all I have to say right now.
Why did they go to Central Marin? The reason is they had been cheated for 30 years. That's the truth. They had absolutely been cheated.
You know that? You know that? Okay, so Tom, where do you get those facts?
Well, because
Let's see your facts.
they got charged the same amount as, say, a homeowner in San Anselmo or Kentfield or Fairfax. And for those homeowners, our district provides sewer cleaning, rotting manhole, lower lateral connection items. And in essence, we maintain collection facilities. In San Quentin Prison, we didn't do any of that. The only probably service we provided was probably a pickup truck drive-by at the pump station. And so we charge the same as we charged somebody's getting full service when they were only getting partial service. In this agreement, one of the settlement agreements does not allow San Quentin to go back and argue in court that we've overcharged them. That's one of the big
Is that
benefits.
where this is all coming from? Or
It's one of the things, yes, Pam.
So that is the biggest thing, is fear of a lawsuit from the state?
You know the biggest thing by far is that sewage is not a big deal. Wastewater is so important, but it's not a competitive thing. And this is what I think the most important thing is. We are tangling with our neighborhood wastewater agencies. It's been going on for years. And there's lots of, and you know, we've got a huge vested interest that Santa Fe does well, that Novato does well, that Sausalito. We're all discharging into San Francisco Bay. If one of the other agencies isn't doing a good job, we suffer. You know, it's our bay, we're interested in the environment. So wastewater shouldn't be competitive. It's not supposed to be a fight. It's supposed to be a cooperative society. And we have a number of areas where we can save on technical advice. For example, we need a SCADA technician. It's an IT thing, SCADA, system communication and data acquisition. And high tech with wastewater now, you can run these, you can monitor everything from one place, you know, read what's happening. But it's not worth our while to hire one person to do that. But Central Marin has a SCADA system. And we were trying to negotiate with them. We can't contract with CMSA because CMSA, our lawsuit says we can't, CMSA can't contract. It's ridiculous. So that's what I think is the most important. Yes, we are going to save money, and yes, we're going to do wastewater the way it should be done. And we're going to, one, guarantee that they can't come into our, the rest of our collection system without our express permission. And two, we're going to make sure that we don't get back sued. And three, we're going to straighten up all these areas of concern and disagreement. It's a 30-plus-year-old JPA. It needs to be updated. And that's another major consideration for us.
Well, you also, Tom, you didn't say, you know, the San Quentin is based on EDUs, like all the other communities.
For treatment.
So I'm just saying that we followed those numbers. And unfortunately, the monitoring system was either not accurate or poorly recorded or given their false data. I don't really know. But I do know what I was told then about the conservation program and how the numbers did decrease. And actually, I had asked Greg, after the one-year contract that CMSA did with San Quentin, I was like, why aren't we reaching out to CMSA to negotiate a bid with our agency? Why didn't we negotiate even lower? And we didn't. It wasn't even brought to the board. So, you know, there's more than just your story.
We were suing them.
So.
We were suing them. We were in the middle of a lawsuit with our sister agency.
They had felt cheated for
Oh, I know.
Finally,
I hear it
somebody at the San Quentin prison finally got hip to the fact that, wait a minute, how much are we paying for this service?
So do we give away our public asset
how much are we
because they're
paying?
pissed off
Just
at
a
us?
minute, Pam.
Well,
Excuse me. And so, I don't think they would have even, I don't think they would have even accepted a bid from us because they were furious.
One of the things that has been brought up since last September, when this whole thing started, was first of all, don't give away the pump station. We don't own a pump station. That's not even. So it's a pipeline there. Don't give away your asset. One of the things that I'm proud to say that we've done since we've been here is we've talked about laterals. You know, and it used to be, you know, the homeowner owned their lateral, and that was an asset. You know what? Now that lateral has become a detriment to the homeowners, because if you try to go to sell your house, that lateral, which is it's worth something, it's my property, I own it. Well, now you got to fix it. Whatever it costs, you got to fix it. So at what point does our asset, this pipe, become a liability? As Greg said, it's a 40-year-old pipe. It's never been looked at, or is that the asset? Is that the asset we're talking about? We didn't pay for it. We haven't supposedly an easement. There's some questions about the other thing. We keep on talking about it as this major asset. says we're not gonna make any money off it, we can't, we're a not-for-profit agency. In fact, we have been a losing money for a long time agency.
Give it all
We're
away.
trying to do better. We're trying to do better.
I'd like to take a break. We've been here for 2 hours doing this. Can we have a 5-minute break?
Absolutely.
Yeah, let's say, just before it's
I would walk outside, I will not do it. If I'm listening to somebody's Brown. I'm just saying.
Michael?
How's the Warriors today? Warriors are ahead.
Okay, board members, we completed attachment A. So just a few questions on attachment B. That settlement agreement and general release between Ross Valley Sanitary District and the state of California.
Excuse me, there were 4 more copies back there. Please share them. I guess they're all gone.
Okay, so, okay.
Thank you.
So I go over to page 2. And this is kind of the recitals, what it's saying. It says, that in 1981, the 1981 agreement anticipated the annexation of state property consisting of San Quentin to Ross Valley Sanitary District for the purpose of sewage service. On May 10, 1985, the Local Agency Formation Commission, LAFCO, denied the proposal to annex to Ross Valley. California Department of Correction Rehabilitation terminated the 1981 agreement with Ross Valley Sanitary District effective June 30th, 2012. So, what is that, 31 years later. And then they entered into a wastewater management agreement with CMSA. So, if we look at the scope of the agreement, over on page 4, probably one of the keys to this is, well, there's actually two issues. It says in an event state property comprising San Quentin is no longer a state-owned property, California Department of Corrections and Rehabilitation shall provide notification of its intent to terminate wastewater services per the terms of the wastewater service agreement in effect at the time of notification. Or if there is no termination provision in the agreement, then California Department of Corrections and Rehabilitation shall provide reasonable advance notification of its interest to terminate, of its intent to terminate the existing wastewater services agreement. It shall be the new property owner's sole responsibility to secure the necessary wastewater utility services. So who would they go, say it's sold, who would they go to secure wastewater utility services? If this agreement is signed, CMSA is who they would go to. CMSA will now become the collection agency for the San Quentin Peninsula. So that's who they're going to go to. This acts like, oh, they're going to decide who they're going to go to for services. It's decided with this. Any major future development that's going to occur in the Ross Valley, and most of us live in the Ross Valley, and a few from Mill Valley, and a few from Santa Fe. Anything that occurs on the San Quentin Peninsula is adversely going to affect, any major development is going to adversely affect all of us. We're all going to be strangled by the traffic. It's going to be an absolute mess out there. So we read about the actual settlement, the settlement.
On which one?
Now on page 3, number 4 is the settlement. It says Ross Valley Sanitary District abandons and relinquishes any claim to title to the San Quentin force main that connects the San Quentin pump station to a 54-inch interceptor. This includes, in parentheses, includes the portion of the pipe that runs on state land along Surf Street Boulevard, and further. Ross Valley Sanitary District shall quit claim any existing right to title and interest as more fully described in the agreement and grant of easement wastewater facilities. And it's listed in the file. Talks about recorded May 2nd, 1983 official records in Marin County, under the recorder's serial number, and it gives the number. And I guess that's what we were talking about earlier when I was asking Christian some questions about that portion. And so it says that we're going to relinquish any ownership of the pipe, and we're going to quitclaim our ownership of the easement that we own on state property. So earlier I asked Christian, I said, at one point we were arguing in court in Sonoma County before Judge Witt that in fact, when CMSA sued us, we had to spend about $50,000 defending ourselves against the CMSA lawsuit and the County of Marin lawsuit when they went for a summary judgment. That wasn't inexpensive little action, little bit of work that we did. It was expensive. And when the judge ruled up there that there were tribal issues here, one of the key issues was trespass and who owned that pipe. It's clear from the agreement that we own the pipe and that we're going to give it up, and we're going to give up the easement that we own. Ross Valley Sanitary District owns an easement from Sir Francis Drake Boulevard over towards H Unit. And so if you're not familiar with San Quentin, there's the West Gate, and then there's the ranch, and then there's H Unit, and then there's the main prison. We're going to give that up. So again, maybe if I can ask Christian, Christian, and I don't mean to put you on a spot on the one hand, but I do. I'm trying to get the rationale as how we went from we own it to we don't own it, it's yours. Now I know you said you were directed by the board, and there's 5 of us here, and I want to tell you that I wasn't one of those that directed you to do this. So I'm just trying to connect the dots from where we were when we argued in court and went before Judge Bettinelli at JAMS in San Francisco and this settlement. How do we get from we own it to we're giving it up? I mean, was it just because a majority of the board said do whatever you have to do to settle? I mean, how did we get here?
Director Ager, as I believe you should recall, there were a number of principles put together in the settlement discussions with the parties. The attorneys were not part of. And I believe they were maybe entitled draft settlement principles. Those principles which are outlined in section 4 of the settlement agreement, in fact, all 3 settlement agreements, were negotiated by those parties, and then I was directed by this board to implement and negotiate final settlement agreements, which you now have before you. So that is where the position that Ross Valley would relinquish any rights as part of the settlement agreement to the force main and the easement associated.
We do own the easement. Any question about that at all? Is there any question? Does anybody question?
Yeah, there are questions.
Are you asking me?
I ask you.
Well, I have taken the position that Ross Valley owns the pipe.
The easement.
So
The easement or the pipe?
both.
Well, yeah, I'm sorry if I have not been precise. The purpose of having the easement is for the pipe. If the pipe is not there, there would be no point of having an easement.
So what do you get in return for
Thank
relinquishing
you.
those?
So, the last, my second meeting on this board was in December of 2010. I came on board, brand new board member, and we were in a closed session in Santa Fe over a lawsuit. It was a lawsuit with the former parties that were going to develop the 10-acre piece that Ross Valley owns over here at Larkspur Landing. I walked into the meeting. I didn't have this much of information, although I had a settlement agreement. But this is all done in closed session. So I was asking, I said, how, I'm trying to figure this whole thing out. Because we were paying $4.75 million of taxpayer money, Ross Valley taxpayer money, to the party that sued us as part of a settlement. In that closed session, I questioned. I said, from everything I see, we need to go to trial on this. It's clear we can win this lawsuit. Now, it was the first night that Berliner Cohen was just coming on to handle our legal account. They were going to be our lawyers. And so this whole thing, when I questioned the then lawyer who was there about how we arrived at that settlement, $4.75 million, he said, well, I didn't negotiate the settlement. Your general manager negotiated the settlement. And I said, well, who was our lawyer with the general manager in the settlement discussions? There was no lawyer. So it was a layperson made the decision to prepare this settlement, to agree to it, and to pay $4.75 million. I had the same sneaking feeling about this settlement tonight. This settlement was put together by board members, conflicted board members, and our attorneys weren't involved with it. But our attorneys tried to pick up the pieces and said, well, board, you know, this is what you've come up with. Okay, we'll do our best for you. And that's how we got from we own it to we're giving it away.
Director Ager.
Yes.
I believe in that settlement, the campus settlement?
Yes.
That was a different law firm. That was not Berliner Cohen.
I told you, I said it was not Berliner Cohen. Oh, no, absolutely not. No. In fact, Jolie was there that night, and I remember Jolie saying, I think Director Ager has some good comments here. Maybe you ought to be paying attention to what he's saying. Jolie said that. Yeah. No, it was her first meeting, you know, and we had other counsel that took what was proposed for a settlement and put it together, and the board voted on it.
If I could take a second, just let me know when. I do have one thing I'd like to say. I'm sorry if I'm boring someone.
We're bored enough.
The John Juco, along with Greg, and to be part of those talks. In the beginning, they were talks. They weren't anything more than that. And go ahead.
So on a closed session, the board unanimously, the first time, said Tom and Greg meet Jason and somebody at the Central Northern Board. And so we thought maybe Al Burrow would be a good one. Other board members were either brand new there or hostile. And so we were hoping that we could meet somebody that would be reasonable. There's been a lot of talk that Katie Rice is there as moderator and representing San Rafael. It turns out that Katie Rice's supervisory district is virtually the same as Ross Valley. It's really close. So she was a very logical. We also went to Levine's office. Is that right?
I don't recall that.
Who was the one we talked to his chief of staff? We went to another, you remember? Well, anyway, I know we did. Do you remember? When we were going to get a staff member, and he was up in Sacramento. So Katie Rice, the supervisor, did not negotiate anything. She didn't sit in, and Jason, you can tell me that. She was trying to keep us together because at the first couple of meetings, quite frankly, Central One didn't trust us. And that's the situation that's been going on. And Greg and I had very little, it was difficult to talk to them because they were having problems with us. So Katie's role there, I thought was absolutely excellent. She kept urging us, what's the next step? Was about it. And when are we going to meet? What do you want to do next? And she wasn't telling us. She was asking us, what next? And I feel like the first meeting, we outlined what a legal problems were. The next, and we brought it back to the board at closed session. And then the next meeting, we looked at areas where we kind of agreed. And then we tried to figure out some more principles. And we said, okay, as a board, along these lines, try to work out some of the details. And pretty much the staff and legal counsel worked it out from there. But we had given out general guidelines, and they brought them back, and we got, I don't know how many draft sets of, proposed or settlement principles. So it's gone through months and months. Probably started in September, or so, last year, maybe August, I'm not sure. And now it's almost June. The next point on this settlement agreement, we've heard that, we're going to relinquish a claim. Do we have a claim, we think, to the pipeline? They think they have a claim to the pipeline. So if it's not, yeah, we own it, and they don't. That's a matter of the lawsuit. But we also put in here, the next one is that they relieve us of all financial responsibility, including any past transgressions that may have occurred. So that's a key point here. And I'll point out again that this is essentially the status quo of what's happening now. There's no change in revenues. There's no change in who's doing what. This is what's happening now.
One question for council. Will the JPA need to be amended for this to be finalized?
It's my understanding that we need to amend the JPA, and my assumption is that it needs to be amended. I haven't studied that question in particular of whether, because of the settlement agreement, the JPA has to be amended.
But you need all the agencies to agree on the JPA amendment. So if they don't agree on this, then that means that this is null and void, correct?
I'm going to turn to Christian.
No, I don't think that would be the case for tonight. You would just have a JPA that is in conflict with a settlement agreement.
You've got to be kidding. A JPA in conflict?
Yes.
How does that serve the community to have a JPA in conflict then?
Well, if you go back to the draft settlement principles that you were given last year, one of the principles was, in fact, the parties would update the JPA.
But that's not in this.
No.
And why not?
Because that's not, well, one, it's not CMSA, excuse me, the prison and the state defendants are not parties to the JPA. They're not members.
But CMSA is.
Yes, but this is the state defendant settlement agreement.
It doesn't feel right. It doesn't feel clean if you're saying there'll be a conflict.
The entire lawsuit was based on the conflict of interpretation of the JPA. I mean, the JPA's position or CMSA's position was, who are we to determine who owns what pipe, specifically when it is on a non-member's property. Now, I'm not agreeing with that, but that's in very broad strokes one of the arguments that they make. And so certainly the contract that they entered into.
There is on page 3 under the settlement, it says, CMSA is prohibited from providing wastewater collection and treatment service to properties located within a JPA member agency's service area unless explicitly requested and approved by that specific JPA member agency's board. So that to me is saying, is there still this hanging JPA issue? Is that, am I reading it wrong, or can you comment on that?
Just so we're on the same page. You're
Page
now-
3.
No, she's on amendment.
You're on settlement agreement A, not settlement agreement B.
Right, sorry.
Okay, thank you. No, I just want to make sure we're talking about the same thing. And so you said page 3.
Paragraph midway, this is CMSA is prohibited.
And so if you wouldn't mind, repeat your question for me, I understand the question.
If the last part of the question, it says, unless explicitly requested and approved by that specific JPA member's agency board. I don't understand that.
Okay.
And does that mean that there's still this issue about whether or not CMSA is prohibited from providing wastewater collection and treatment? Go ahead.
What this clause relates to is, and maybe I can, there was discussion some time ago regarding what would happen if CMSA decided to contract with Warren General. This prohibits that. Unless this board explicitly states, CMSA, please you may, or agrees to, you may contract with Warren General Hospital to provide wastewater transportation and collection services.
Well, it says, it doesn't mean us. It doesn't just say us on it. It could be
That
any-
specific JPA member
That-
agency,
that
we would be
JPA.
that specific JPA member agencies. That would be us. Or San Juan.
Right, so it doesn't mean just us.
No,
That
I
would be an
mean all of
example.
them.
Okay.
Anything else?
I'd like to ask just a quick question out to the board. What's the hurry?
3 years too late. Please.
What is the
Guys,
hurry?
Please. 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 Last September, I just started getting emails about, please don't hurry. Please don't hurry. Please don't hurry. Take your time. Think about it. And if there's anybody out there who doesn't think that I have spent sleepless nights thinking about this, because I take this very seriously. I do. We aren't rushing anything, we haven't rushed anything. What you see in front of you is not rushed. It didn't get presented to us last Friday, and we said, okay, let's rush. This has been in front of us, we have been wordsmithing for ages, and for reasons which have been explained, we can't do, please don't. That's what we were instructed to do. And that's when you were trying to settle a lawsuit, do it to the best of my understanding behind closed doors. It can't be done any other way. Otherwise, should you decide you want to settle, go to litigate, you've given away all of your private knowledge that you know, so that the defendants can then know what your strategy is. You can't do that. This is not rushed, so there is no rush, and why not? That's,
I just brought that up because of the community.
I understand that. We could have done this. Shh, please, Richard, don't, please, just don't.
Are we done with B?
Let's go, let's go this.
Well, it's interesting, Michael's comments did just look into more questions. So when was the public first noticed that these settlement negotiations were going on?
When did you tell us?
You emailed them things, that was pretty early on.
When do you think the public first knew?
I'm being very serious, Frank.
Months
When
ago.
you emailed them about, excuse me, troubles of let me quote it, troubles of brewing at the Ross Valley Sanitary Agency.
I sent that out?
Yep.
Really?
Yep.
Can you get me a copy? of
Yes,
that?
I absolutely will.
Don't be an ass, Frank.
I absolutely will. This is the Lucas
Can you bring
Valley.
this to order? Mr.
Yeah,
Chairman,
you're
please?
close to being thrown out of the meeting.
Okay.
Just tell me, one more pop out of you, and I'm going to stop the meeting until you leave. No, again.
I know. Look. Yeah, I'm happy to provide it. I don't have it with me. I probably should have printed it, but I didn't. I mean, there are a lot of people who send me a lot of different emails from different things, and your name has appeared on many of them, and that was one of them. Troubles of brewing at the Ross. He who controls future development at San Quentin.
Did I say
Yes,
that?
absolutely. I will.
Did I use that word, huh? I don't think I've ever used that word.
Well,
Allegations are.
But anyway, you know, maybe we should just ask the folks here.
No, we're not asking the folks.
No,
If they could just raise their hand. When did
No,
they first hear there was a settlement going on?
I read it in the newspaper, in your article, that
Oh,
you're
I
gonna
wrote
give
it.
away,
Right.
you're gonna give away the pipeline. That was not.
When was that?
That was a,
What do you think that was?
that was a closed session item, Frank.
Was that in February?
I don't
I don't know.
Yeah, maybe it's.
Michael wrote one, so this has been two more invoices. I wrote one, you wrote. You know, IJ treats everybody fairly, each side don't
I mean, yours was very early, so the question was, when did people start hearing about it? You asked the question, and it was months and months ago.
Is there any agenda where we had a notification that the board was discussing a settlement agreement and the attorneys were given direction regarding the potential settlement agreement? Can we see that on some agenda? Since we're a public agency, everything's public, right? We report out everything.
Do you want to know what the agenda said? They said existing or pending litigation, and they listed out the name of the litigation, which is exactly what the government code tells us to say in the agenda.
And we never reported out any direction.
And then we reported out, we gave
Any
directions.
vote, we didn't report out a vote, I don't mean direction.
We didn't,
A vote.
we didn't report any substance of what was discussed, which is proper.
But don't we have to report out what the vote was?
No, not if you're in existing litigation. Once the litigation is settled or ends, then that is what is reported out. But the Brown Act is very clear about what doesn't have to be reported out. So there was nothing improper about the way this item was agendized over the months, at least since I've been general counsel, which is since February.
I don't remember an agenda saying this is a pending settlement negotiation.
We can look back,
What
but,
did it say? It said,
right, tonight it says,
Discuss,
tonight in the just-in-case closed session, conference with legal counsel, existing litigation, it lists the government code section and then the name of the pending litigation.
okay.
That's what-
How would the general public understand what that meant? Are they supposed to be mind readers or?
They read their newspaper article.
The Brown Act is very clear that when you're talking about pending litigation, this is the only information you have to give.
You know, if I counted all my fingers and toes, it would never cover the amount of unlawful Brown Act violations that I've seen occur at public agencies over the years.
It's not.
Pretty common. It's
Right.
pretty common.
I agree with you.
Public agency attorneys take their boards, commissions, and councils into closed session at the drop of a hat. I was in one a few months ago and I said to the attorney, this is an illegal meeting under the Brown Act. Oh, no, the attorney said, no, according to this code section, you have a right to be in here. Well, you know, the problem is, we take care of the public's business in secret all the time. I'm not pointing fingers at, you know, listen, I've been on way too many agencies to count. But anyway, this is what I've seen over the years.
Any other discussion on the points in,
Let's go on to C at this point.
should we go to C?
Okay, C, let's see, C is a settlement agreement and general release between the plaintiff, Sanitary District Number 1, and defendant Marie County.
Who got stuck in the middle of this whole thing? It's very short. Marin County, the owner of the San Quentin Village SMD system, shall update its agreements with San Quentin Prison and CMSA to explicitly permit wastewater flow through the San Quentin State Prison System for treatment by CMSA. Such updated agreements shall address the rates to be paid by San Quentin Village residents and Marin County's financial commitments regarding cost of wastewater treatment and long-term capital asset replacement of joint use conveyance facilities. 2. CMSA Joint Power Agency's members shall not be responsible for any future costs to replace or improve the wastewater conveyance facilities located within San Quentin Village, including if and when the existing prison transitions from state use to other uses. Marin County may contract with CMSA, a CMSA member agency, or qualified private company to operate and maintain the wastewater treatment services. Upon the approval and execution of this formal written settlement agreement between RVSD and Marin County, the attorneys from Marin County and RVSD shall jointly notify the Sonoma Superior Court that a conditional settlement agreement has been reached, conditions being the requirement that the RVSD reach a settlement with CMSA, CDCR, and the California Department of General Services, and to set the matter for an order to show cause. Reason, settlement, and dismissal in July 2015. That's what it says.
So a question, it says that conditional settlement agreement has been reached. Conditions being and we're going to notify the court that a conditional settlement agreement has been reached. Upon approval, right. So what, again, maybe our attorney can tell us, what is the benefit to the Ross Valley Sanitary of this litigation? And the settlement. How would we benefit? What's the pluses for us?
On settlement agreement C?
C or D or A, yeah, any of them.
Okay, I can, why don't I start with A, and go right through them. I think the principal benefit that the Ross Valley is receiving from these settlement agreements is release of liability. Also, release of, as stated on page 2, recognizing the time, expense, effort, and risk to them involving in this dispute by litigation.
What litigation did
So,
did CMS sue? No, is there a pending lawsuit?
This,
and with CMSA, the attempt to update the JPA, good government, but primarily the release of liability of a very old pipe. And also, you have you have a transfer of the pipe. It's not a giveaway. There was a dispute over ownership of that pipe, and it's being resolved by determining that the prison owns the pipe, including the contract with CMSA.
Did the prison sue? Is there an outstanding lawsuit by CMSA that you are releasing the claims to?
The board can direct.
You want to answer that question?
Answer the question.
There's one lawsuit. It's Ross Valley versus.
It's this lawsuit.
Yes.
But it must be a mutual release of claims.
We really can't.
No. I mean, you have to get something in return for a settlement.
She's a lawyer.
It doesn't.
Probably a better lawyer than me.
That was really out of order, Nancy. Please don't do that. Please don't do that.
Okay.
We could have done this in closed session. And the fact that this is happening in public is we wanted to do this. It may, please don't do that.
in response to that question, so we've been relieved of any liability because it's very old pipe. Is that kind of is that what I get out of that?
Well, that was a discussion that this board had.
Okay, so let me tell you about that pipe. It's 31 years old. That pipe is some of the newest pipe we have in the ground. We've got pipe that's 50, 60, 70, 80 years old in the ground. So 31-year-old pipe is, liability is pretty low. I mean,
Except that nobody's looked at it for 31 years.
well, we were supposedly TVing every pipe that we have.
We have our pipes.
So that's our benefit, that's what Ross Valley gets out of this. So we won't be held liable if something blows up, like a pump station or a force main.
And they won't be held liable if they brought a lawsuit that we overcharged them.
There was that issue that was discussed earlier. Also, the agreement that CMSA is prohibited from providing wastewater collection and treatment services to other entities within our.
In the recitals, Frank said that, well, not in the recitals, but Frank was mentioning that we're giving new powers to the JPA. We didn't have recitals in attachment A. The very first recital, it says that CMSA was a joint powers agency formed with the following powers to either joint facilities for collection, treatment, reclamation, and disposal of sewage. So they already have the power to provide collection service, at least if that recital is correct.
Is that your second slide?
Jason says it.
I think if you go back to the original documents, the contract was with the entity that is now CMSA, not Ross Valley, not SB2. So, I mean, that was the contracting agency that was contracting to build what is now this system.
Let me also just, you ask, what do we get in return? There's some other tangibles I feel that we get out that are going to be extremely important going into the collection center of the future. In our recent talks about who we need on our staff, we got really old pumps in our pump stations in the Ross Valley. We do not have the expertise on staff to fix the large pumps, is my understanding. But Mr. Dow at the CMSA has that expertise. If we're not fighting with our sister agencies, we can start to get some collaboration. My God, if all of a sudden we have an emergency here, maybe we could call Santerfell and say, hey, could you, Public Works, could you come out and help us over here? Oh, no, we can't, you're suing us.
No, we have that agreement with them right now.
But we don't have it with CMSA, because we are suing them. We can't go. It would be much gentler if we all kind of could, from here, whatever happened in the past, happen. Let's try not to have it happen again. Let's move forward with good governance where the community agencies can talk to each other and get stuff done without fighting and bickering. I mean, that's.
When we were operating the prison facilities, we were operating a pump station. And that pump station was built in 1984, or probably went into operation in 1984. Oh, right, Jason, right? And we are now doing 2 pump station rehab projects. Pump stations, I believe it's 13 and 15. 12 and 13. They're down there by Bon Air. They were completely rehabbed in 1984. We have to really redo them at the tune of about $10 million. And so that San Quentin pump station is the same age. And I can assure you, we didn't do a lot of work on that pump station as a district, even though we were collecting money. So that's the same age as pump stations 12 and 13. And we're in for $10 million on that. And we've got projects going right now. I think the design is out. And then we're going to get a construction project. So that's a major liability for us as well.
Well, actually,
Then this-
CMSA is just now doing a partial rebuild on that pump station. They're spending about $120,000 on that.
That's good. That's something probably we should do. Who's paying for that rehab?
San Quentin will end up paying for it. The charges be passed on.
Yes, we should.
We're talking about, we don't have the staff, the expertise to handle our operation. If we don't have the expertise to handle running this district, then maybe we ought to be out of this business. We have 3 engineers on staff. We went from 18 employees to 38 employees over a period of about 5.5 years. And we're still contracting out millions of dollars in work because we don't have the expertise on staff. I think we do have the expertise in staff, and I think we have to start using them rather than contracting all this out. We have 3 engineers on staff, flat out. Anything else?
I have a question for the council. So, if there's no appeal process for the community, if this goes ahead tonight, like, a lot of.
To appeal the board's decision to settle the lawsuit?
Yeah.
Not that I'm aware of. I mean, a member of the public can always
Well, we already have a
challenge.
lawsuit. We already have a lawsuit.
Well, a member of the public can always challenge a decision of a public agency through a writ proceeding.
I'm sorry, who can do the writ?
A member of the public can challenge an agency decision if it's arbitrary and capricious. So there's always recourse for somebody wanting to challenge a public agency decision, but that's a little different from the rest.
Yeah, so there is a process for a writ. Okay, and that has to be within how many days? Is it 10? Like, there's something about here on 10 on the final agreement.
I can't speak to the specifics of what the agreement says about a challenge period.
Unrelated issue.
That's not related.
Okay, well, what's the pleasure of the board?
Well, I've been very clear with what I would like to do. And I have taken into consideration all members of the public who have cared to contact me. And I really thought this out. So I would move that we approve, a motion that we approve the settlement agreements with the Central Marin Sanitary Agency, California Department of Corrections and Rehabilitation, and the County of Marin in Sonoma County Superior Court case number SCV-252383. And
I'd like to make a motion.
Maybe we have a motion, so.
You just asked what the board's pleasure was. Michael is not the only board member here. So I'm asking for a table of discussion.
So here, sorry, just
I
as
recognize-
an order,
I
so
recognize my-
if there's a motion on the table, I would first suggest to see if there's a second, and then if you have a substitute motion to put on the table, then you could do a substitute motion.
A substitute, okay.
I'll second the motion.
Pamela, you,
Okay, so my motion is that we give the ratepayers 45 days to review the proposed settlement. But we also come back to the table and create some new leadership with a community advice committee so they can participate in a different settlement, perhaps with CMSA and RVSD where there's a win-win and there's not a lopsided settlement. I also want to know any economic impacts, not only for the ratepayers, but also, this has been discussed at many meetings on how the, what we're giving up. There must be a cost on it. There must be some issue or concern. This is a policy, and I really don't know. We never got that information. I've asked Greg, I've asked attorneys, they have the same answers, we really don't know. And also, we have not done binding arbitration, and I think the community is very clear that they really feel that is one way to look at this. And that is coming from the voice of the community and from democracy and the process. So that's where I'm at with this right now.
So is that a motion to continue or table? What was it? What's the motion?
It's to continue
A substitute
to
motion
look
to
at
continue for
potentially.
45 days?
Yeah, but a different settlement that could possibly change some of the dynamics, which we never discussed. And possibly working out a different settlement with CMSA, so that we walk away with the community that it looks like it's more fair and more agreeable. And get an advisory committee from the public to be part of that.
I'll second the motion.
So we already have a motion on the board.
Yeah, so the way this works, some of the rules that you've adopted is you proceed first with the last motion. So you first proceed with a vote or a roll call on the substitute motion. If that passes, then the original motion is moved. If it doesn't pass, then you do a call on the first motion.
Can it be discussed?
Sure. Yeah.
Discussion?
You gonna discuss?
So, it makes sense. I mean, the community's been asking for additional time to review the settlements. There were a few that were handed out tonight, but most of the folks here, if they didn't go to the website and print it and read it, they really haven't seen it. Makes sense to give them 45 days to review it. Makes sense for our board to try to bring the community together to come up with a settlement that's gonna benefit everybody. This one, Lost Valley Sanitary District, lose. There's nothing in it for us. There's no consideration. But an additional 45 days, and 45 days in the life of this litigation is really nothing. It's nothing at all. And it makes sense to at least give the public the opportunity to be fully informed and even participate. It makes sense to me.
And it also warrants dropping the lawsuit. Does that not?
Well, let's get through one motion.
Oh, okay. All right.
What? I didn't understand the last part.
Never mind.
Can I just ask for clarification on the motion, just so I understand it? It sounds like it's trying to do two things. Number one, it's trying to postpone the discussion of this particular settlement agreement for 45 days. It's also trying to put in motion a totally different process that comes up with a different settlement agreement. Is that what your intent is?
Possibly, but to have an advisory committee from the public be part of the discussion.
Well, that should probably follow the motion to continue for 45 days, rather than mix it into two.
Well, I'm just concerned that on the second half of it, I'm not sure what the process is, or, I mean, I guess the board would need to discuss what, how is the advisory committee going to be constituted, and when, what's the timeline, that kind of stuff. I'm just trying to get clarification on the motion so that the board understands what it is.
From what my experience is, and maybe Frank, you can chime in, these advisory committees are just critical on helping us see where the public and community thinks and understands or doesn't understand, to create more trust and help us have a vote that I feel good about. It is not a great feeling to be a split board up here on a huge settlement like this, and then hear that we're going to be sued. So, and emails and recalls. So I'm trying to create potentially a win-win for the community and the board. This is where I'm coming from. And that's why I'm asking for a 45-day review of the proposed settlement.
Yeah, but I think we need a clear motion. I don't think any of us.
And the motion should be to continue this item for 45 days.
Okay.
And then, after that, we could have, if it
yeah,
passes,
that's-
we could have another some discussion about where it's going, what's going to happen. in the next
Okay,
45 days.
I get it, maybe that's too busy, too much to ponder. Okay, so continuance for 45 days.
And you second that, Frank?
I did.
Okay, so where did the 45 days come from?
Community, myself.
What? No, I mean, we've heard 45 days. Where did that come from? Why 45 days?
Well, the public's been saying 45 days. I've never said 45 days. The public's been saying 45 days.
You seconded
Is
the
the
motion.
public allowed to answer the question?
So that came from the
So
public.
you're asking?
That was a question of the board. Okay, let's vote on it.
I would just make the comment that my understanding is that all the other parties to the settlement agreements, CMSA, CDCR, and the county have already approved. Yes?
And the CDC has no.
No, I understand CMSA has. I understand the county is going to be taken up soon, and it is with the party or the department heads that we see at CDCR and General Services, but I don't have a firm date from them.
And it's the exact verbiage that we're looking at.
Yes, they're all looking at the same.
And so if we start tinkering and we have a community advisory board, we are starting over.
Right, I mean, if we were to change, say, settlement A in any substantive way, I would assume CMSA would have to go review those changes and approve those.
You know, we've heard about binding arbitration, and frankly, I wish that had come up 3 years ago, as opposed to starting this lawsuit. I think this lawsuit is one of the last vestiges of Brett Richards. And it started because, well, I don't know why it started, but San Quentin prison wasn't being fairly treated, or didn't believe they were being fairly treated. So as a reaction, we filed this lawsuit. And we've been at it for 3 years, and nothing has been resolved. And we're still going at it. I don't know what 45 days is going to do for us.
Let's take a vote. Motion.
You don't think
Well,
having,
if I may, just, you know, at some point, we have to stop blaming Brett Richards, everything that's happening with the Ross Valley Sanitary District. He's been going for 3 years. I mean,
Well, this is his legacy.
yeah, right.
Sure. President, on that motion?
I just want to comment that I'm just wondering how the 3 board members who I know want the settlement, how do they think or feel about all the community showing up and what they're saying? I feel like there's a wall partially up here. And I haven't seen this before, and I'm just wondering why the community does not get potentially a little bit longer to review this.
Well,
Why your decisions are more important than the public.
Here, here. Can I please respond to that?
Wait, no, I'm not done.
That's
You,
why I asked.
wait, I'm not done.
That's
You
why
are
I
elected, you are elected by all of the people. Not one supervisor, not one agency, not your friends here. So you might want to reconsider thinking about continuing and the fallout. You want to make this community, this agency and the community be more trustworthy, then I would suggest you do the 45-day review.
May I make one comment?
No, we don't want to hear anything, we're just going to do it.
You're the public.
I'm the public. I do listen to the public. I've spoken with with many of you, the same public who shows up at our meetings and are absolutely concerned. I've also spoken with many people in our communities who have not shown up to the meetings. And so I have direction, Pam, in both ways. And I am paying attention. And, you know, we have 50,000 constituents out there. And we're going to have to do what we're going to have to do. And come next year for several of us, and a few years down the road for the rest of us, if they don't approve of what we've done, so be it. I am Anyway, I hear what you're saying, Pam, and I'm listening. So let's, what do we do next?
So we ready to vote? All in favor? I think we're going to do a roll call. I don't know.
Roll call's fine.
Roll call, do a roll call.
Okay, make the motion clear on what the vote is, please.
It's what I heard is that the motion is to postpone this decision for 45 days for the purpose of giving the public an additional 45 days to review the proposed settlement agreements.
Period, yes. Yes.
Okay.
Okay, roll call.
Borstein,
No.
Silla, Meggs,
Yes.
Egger,
Aye.
Gaffney.
No. Okay, would another substitute motion be in order? I would so move, if it is, that we dismiss the lawsuit against CMSA, the California Department of Corrections and Rehabilitation of the County of Marin.
I'll second.
That would, I think, absolutely make sense. That would put us, that would be giving up the $450,000 that is the option that is most absurd that has been discussed.
You're giving up everything anyway, so you're not the lawsuit. We won't be fighting, we will not be fighting with our sister
Well,
agency.
so let's see.
Excuse me, gotta ask your attorney on this.
Question.
Let me frame-
What's the ramifications of dismissal?
I apologize for interrupting. Ask
No,
your attorney.
please don't.
If you dismiss
No,
something,
don't
the
interrupt.
prevailing
Be
party
quiet. No,
can
please
be
don't.
entitled to attorney.
Please don't.
Not-
Please don't. Don't do it.
Yes, we have discussed this, I mean, Director Meggs has asked us a number of times, has asked me a number of times, what would happen if we just dismissed the lawsuit? We would be potentially subject to an attorney's fees motion against, brought by the county, CMSA, and the state courts.
If we just draw.
Yes, and we, there would be statutory, statute of limitations issues that may prevent us from bringing the lawsuit later on. I will say, with trespass, that is not the case, because generally trespass is an ongoing offense. So in essence, every single day, you have a new trespass. However, with the way this lawsuit, the issue in this lawsuit being the easement of ownership, there may be, and I prefer not to go into much detail, there could be some problems.
You've represented public agencies for a long time, Berliner Code, down to Grant. Can either of you tell me when you saw a public agency versus public agency lawsuit that resulted in a court award of fees and costs? When I've been involved with public agency lawsuits, generally the court doesn't award fees and costs. It's each agency kind of pays their own. Can you think it's a realistic downside?
Director Agar, I said we would be subject to a motion. I am not a court. I can't tell you how the court would view this necessarily. So, and again, I think that these are issues that I think that I would prefer to discuss with the board outside of public view, because I could be giving you a roadmap.
Sure.
In the event that this board decides to do, take up this motion and vote to just dismiss the lawsuit instead of the settlement agreements, I would be giving potentially the defendants a roadmap.
Okay, so the motion is to in effect dismiss, direct the attorneys to prepare dismissal, papers for dismissal. It would have to come back to the board for discussion and final action. It changed the course of this.
If the board would direct me to dismiss this lawsuit, I would file a request for dismissal. It's a California form. It would not, I don't believe it would need to come back to the board unless your counsel thought that there should be a second vote. There are no cross complaints filed in this action, so I would not need the approval of the other parties. And I would need the approval anyway, but they don't have ongoing litigation outside of their answers. So my filing of the dismissal and the court entering that dismissal would effectively end the lawsuit.
Andrea, what do you?
I would
give a
strongly
sense?
advise that before that motion is strongly considered, that you do in a closed session review advice from your litigating attorney. Given what Christian has said to you about his level of comfort.
Did you make a motion?
Well, my motion was to direct staff to prepare dismissal. Perhaps that motion ought to be to adjourn to a closed session to discuss dismissal and the ramifications. Does that make sense? If we're gonna do that, it would be wise to do that in a closed session rather than an open session? Would you feel more comfortable in that?
You're asking which one of you, I'm sorry, you see what we're looking.
Yeah.
I either one.
Well, I think I've already stated that.
Yeah, I know.
I'm reluctant to give a roadmap.
Right, I understand. And you kind of agree with Christian.
That it would be appropriate that if you were to consider a motion like that, that you would want to hear from your attorney in closed session.
Okay.
So I wouldn't disagree with gauging the board's interest in going into closed session to talk about that motion.
Okay, so that's the motion.
Is that for now?
So
Frank,
I'm sorry,
is that motion to go into closed session now,
for this evening. And then come back. for
before
open session.
the settlement vote?
Before the settlement vote, yes.
Okay, I second that. You think it'd be like? I know.
I'm surprised you want to go into closed session.
It is ironic.
Can we just go back to the first motion?
We'll be there soon, okay? We'll be there soon.
So I guess we need a roll call vote on this.
Can you read back the motion, please? I want to make sure the motion is correct. Which,
Motion is to adjourn to closed session this evening.
for what reason?
To discuss a dismissal.
The dismissal
Okay,
of the lawsuits.
second.
Okay, Borstein?
No.
Wait a minute. I was gonna, actually, a dismissal was my second choice. The last choice, I think, is proceeding with the lawsuit. I think we've essentially lost the lawsuit already.
But to dismiss it gives
But
us
it's-
everything that we have actually negotiated that will take us forward.
Exactly, yeah. I
And
mean, it's a distance out.
I frankly see this as a delaying factor.
Okay, now do the roll call.
Wait a minute, I just want to add that I have been talking about this for months. For dropping the lawsuit. I could just get support from many of the board members, and even Frank is not so supportive of it. But, you know, it's sad that we could not have that discussion a little bit more open and articulated in a way that you're saying, oh, well, perhaps that was a possibility. And that is such a disservice to the community. I hate to say it, but it is. It's a real disservice. So, and that is because I feel there's this wall up with the split of it's your way or no way. And that's what's taken so much problem here, ongoing months and months and months, is that there isn't this openness to create some open dialogue. So, very sad to see that. Go ahead.
Okay. We have a motion to go into closed session. Roll call.
Borstein?
No.
Scylla? No. Meggs?
Yes.
Egger?
Aye.
Gaffney?
No. So now we have a motion on the table to dismiss the lawsuits, or to settle.
Can we speak for that motion?
Yeah, please.
So, Ross Valley Sanitary District treated Sanquin and the State Department of Corrections and Rehabilitation like any other of our customers. And we serve a number of governmental agencies. We're in General Hospital, College of Marin, Tamalpais Tam Valley High School, Tamalpais Union High School District, City of Larkspur, the towns of Ross, San Anselmo, Fairfax, and numerous school districts. We treat them all the same. Their fees are based on flow and strength, just like we build San Quentin. So the reason the bills went up is because the flow and the strength went up. We did turn around and lower those fees that last year. So what's going to happen? Someday the public, when we talk about Ross Valley and all the problems it's had over the years, the grand jury investigated Ross Valley in 2006 and issued a report. There's been 3 grand jury reports and just all kind of activity, and it's covered a number of directors. I mean, we're only a small portion of the number of directors that have been involved with the Ross Valley Sanitary District over the years. And people always say, oh, it's just a terrible agency, they're in trouble all the time, et cetera, et cetera. So one day the public's going to look back on this decision, and they're going to say, that was really an unwise decision. That decision was fraught with conflicts of interest and should never have been approved. And conflicts of interest on all sides. CMSA commissioners, Ross Valley Sanitary District directors, county emergency supervisor. I mean, everybody, there's so many conflicts here that it's obvious that this should have gone to some form of an independent, unbiased third party for either mediation or some adjudication, even a judge. This is just a bad decision for the people of the Ross Valley. And it's a decision that's going to facilitate any future growth in the San Quentin Peninsula. Flat out. CMSA, will be the provider. And I guess LAFCO, they have San Quentin within the Ross Valley Sanitary District service area. They're going to have to change that map and show the San Quentin Peninsula in CMSA service area, because that's what these settlements do. Anyway.
I have a question. Are you done, Frank?
I'm sorry.
Are you done?
Yeah.
So, binding arbitration, what are your thoughts, Tom, on that?
My thoughts? Well, I wish it had come up 3 years ago instead of this lawsuit.
Well, it's coming up right now, so.
I think it's kind of an impossibility right now.
And you speak for yourself without your board
Well, you
member
asked me.
telling you. I know, but it's obvious that they kind of whisper to you what to say.
Can I speak to that, or you just want to hear from Tom?
An observation, Michael. So.
Would you like to hear it?
Well, yes, I'd like to hear it.
In order to binding arbitration, in my opinion, first of all, I think it's an impossibility. We gave away the one reason why CMSA might sit with us when we signed those bond documents. That's what I've heard from our litigator, and that's what I believe. We'd also have to submit to binding arbitration from San Quentin State Prison. Why would they sit with us? They believe they're in the right, and they've got lawyers who will be happy to argue with us, if we wanted to litigate it. So they're not going to. They have nothing to arbitrate. They're getting a good deal. Why would they want to do that? Marin County is the same. Binding arbitration. I'm not a lawyer, but the arbitrator doesn't absolutely have to look at it and go, well, this is the law, so this is what I'm going to do. The arbitrator could say, oh boy, you guys were really doing something wrong under those. You have no idea what's going to happen. And when we're the only people allegedly with skin in the game, I can't see why anybody would sit with us and want to do a binding arbitration. I probably didn't say that eloquently because I'm not an attorney. But that's, once again,
Well, the sad thing is that it never came to the table, so we really don't know. you know, at least you put it out there, people want to say no, that's fine, but it does create dialogue, and it does let us know where they're at, so, to jump from, you know, from one place to 180 degrees to another settlement as such is not serve the public, and I'll tell you, Mike, I'm gonna sleep well knowing how I voted.
We've just been told that the other side gave us too good a deal, and that's why.
So you've got a motion on the floor.
Do it.
You did it. Yeah, you just said that.
What's his opinion? We can't have a discussion.
Any further discussion? Roll call.
What's the motion then?
The motion is to,
Is it my motion?
your motion, to approve the settlement agreements.
Yeah.
Orstein,
Aye.
Scylla,
Aye.
Meggs,
Absolutely not.
Egger,
No.
Gaffney.
Yes.
Don't do that. I don't care which side you're on. Don't do it.
Okay, item number 3, adjourn to closed session. We don't need to do that. Correct, everybody?
Correct.
Item 4, reconvene for open session. We did it. Item 5, open times for public to raise items not on the agenda or for future meetings. Raise public comment on items not on the agenda. Yes. Please come up to the podium.
Technicality, but I just wondered whether it was implicit that your current attorney, I mean, I'm really troubled by the fact that it does not seem to me that there is consideration for this settlement, that there wasn't an outstanding.
You know, this is an agenda item.
But I would just like to know whether there was a recommendation by the current.
I would be happy to sit and entertain these after we close.
Yeah, we can.
No, but because I would like to know from the attorney.
I would like to have us.
That is your recommendation, that this is, there was adequate consideration?
That would be closed session material that I'm elected, again,
No, not-
to give out potential roadmaps.
So he's not.
You're the litigation attorney, the current attorney who is advising the board now. Is there adequate
Number
consideration?
one, the board isn't directing me to answer your question. Number two, I'm not advising the board on the settlement agreement.
You're off because you're on an agenda item. So
I will sit and
we
discuss.
can
until
answer
they-
that after the meeting. I'd be happy to do it.
I have 3 more people waiting.
Okay, we have 3 more.
I want to say I appreciate the effort that the board has made to make things more transparent. And I do think that the board has brought forward things that a lot of times in closed session do not need to come forward. I do believe that the public could be better informed because there are some points of order that need to be complied with, as well as there are some rules of law that, independent of what we want to say or do, precede our decision. And I do think that counsel here, who I'm sorry, that I think you've been grilled and put on a very difficult
This is an
seat.
agenda, this is on the agenda.
Thank you.
No, I know, but I think that he's tried to coach us all to come to a better conversation, myself included, when I interrupted the meeting over there.
Okay, that's good.
Thank you.
Thank you. I get your point. It's not on an agenda item, I hope.
I think that it is probably wise to have taken a vote.
Yeah, okay.
with-
That's an agenda.
She's talking about
We're not gonna do
process.
this.
No, it's an agenda
All
item.
right, I'm
vote.
just gonna read, I heard
It's-
your
it's-
lawyer refuse to state for a fact that notice of this hearing complied with the Brown Act. Perhaps it did if a person has a computer, but there are a lot of people who do not. That's one thing. The second thing is I handed a piece of paper to the clerk before the vote for Mr. Egger, and it was not given to him. So I would like to give it to him now and have him perhaps reconvene your previous
No,
session
no,
so
we're
that
not
he
gonna
can
do that.
ask for another motion. I believe with that motion, you could probably get a unanimous board to vote on this agreement.
a ratepayer in the Ross Valley, I've been shocked at the increases that have come repeatedly with new pipes and cameras and all these other things. When I really don't see anything, I hear that there are cost overruns that were talked about and voted on at the last meeting. I would like to see some details on that. You have a very good PR company that puts out things right before elections and right before we're going to get stabbed with a huge rate increase. I think that it is time that there is a citizen advisory committee put together representing all aspects of the district, the towns, and the unincorporated areas, with maybe several people from each one, so that they can be better informed about what exactly is going on and why, in fact, all these change orders come down and why, in fact, contracts are snatched and illegally taken and no one stands up for the Ross Valley Sanitary District rights, especially the new board members, and under the direction of Mary Silla, who gave you notice to vote in favor of this. The three of you, Gaffney, Bornstein, and Silla, this was a coup that you executed, and whatever you're getting paid for it, I hope it's worth it.
Thank you.
Just adjourn.
I'd like to make a comment about the context within which this meeting tonight is happening. Last night, the National Park Service had a meeting with community groups in Mill Valley where notice was received late in the afternoon before the meeting happened, so that there was no adequate public notice about a memorandum of understanding for what the Park Service is going to be doing with the Golden Gate Recreation Area. Tonight, we have a meeting where the information was not available until an hour and a half into the meeting for people to be able to see the agreement settlement. Tomorrow night, Metropolitan Transportation Commission is having a meeting where public participation is going to be a matter of having talking stations where the public can put post-it notes up within the guise of that being public participation. There is a feeling of something so seriously wrong with democracy, as someone who earlier was, when it was why do we care? There's an issue about democracy, and 3 nights in a row, falling on the heels of a Memorial Day weekend, we're told to be trustworthy of settlements that are happening with all of the confusion, the short notice, and the magnitude of the decisions about Muir Woods, about what might happen in development as this settlement goes to one group, and to the power that MTC, Metropolitan Transportation Commission, and ABAG is gaining in our lives, with local control being diminished.
Where are you from?
Susan.
I'm sorry.
I'm from Mill Valley.
And your name?
Susan Kirsch.
Oh, Susan, I didn't recognize you. I'm sorry.
Okay, so I will try to frame my comments in a way that is not repeating something that was on the agenda. But I'm concerned with a bigger issue, which has been my consistent concern, which is good governance. And what the public want is a process that convincingly includes a bona fide effort to include the public. That includes a really serious effort to notify the public about things of interest to them by all of their available means, which would be publishing notices in the newspaper, giving lots of advance notification and publicity for meetings and documents of interest to the public and to your ratepayers. Secondly, there's consideration of divesting or giving away assets at Ross Valley Sanitary District, because assets are considered to be a liability. And if you follow that to its logical conclusion, at a certain point, maybe it's really not a good idea to have a Ross Valley Sanitary District. And in fact, I've heard that proposed that over time, maybe it would be a good idea to consolidate Ross Valley Sanitary District into something bigger. Now, maybe there are some efficiency or cost benefits to that. But the rub to that, and this is, and I worry that this is kind of where we're going, one little baby step at a time, is that we, the ratepayers, don't have a process for voting the people who make those decisions. And we've found with Plan Bay Area, et cetera, that being run by alphabet agencies takes away our local control. So I'm really hoping that this is not the direction that you want to take us down, because your voters want you to represent us. We don't want that taken away from us through this process or through what comes next in the process.
Thank you. Any other comments from the public? Okay. Time to adjourn.